Please make sure all cell phones are on silent. Hey, all persons having anything to do before the Honorables. The Justices of the Appeals Court, now sitting in Boston, will identify the Commonwealth. Draw near, give attendance, and you shall be heard. I'll say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Henry, and my left, Justice Wood. We will be hearing 5 cases this morning. The rules are, as they always are here, 15 minutes per side and no rebuttal. If parties on one side of the V are splitting their time, and I know we have one example of that sometime today, I think, let us know at the outset what the division you've agreed upon is so that we can make sure the clocks are set properly. We have read your briefs and are very familiar with the facts, so you might want to, given the limited time, just start with your argument, but it is your time and you can do with it as you will. And with that, the first case we will hear today is Commonwealth versus Andrews, number 25158, and we will hear first from Attorney Crouch.
Good morning, and may it please the Court. Andrew Crouch on behalf of Mr. Andrews, who appeals from the denial of his motion to withdraw his guilty plea. I'd like to first begin with the second issue in the brief, the Scott Ferrara first prong issue, before transitioning to the attorney-client privilege issue. Here, the motion judge's determination was largely based upon 2 documents. It was the facts cover sheet and a so-called wet letter. There was testimony at the hearing, but the judge's decision focused on those 2 points. It did not to say that Mr. Andrews had not met his burden of demonstrating the first prong. This court is in reviewing documentary evidence is in just as good a position as the motion judge was in reviewing those documents, because there was not any other witness testimony to contextualize them. So we would suggest that.
Are you challenging any of the motion judge's findings as clearly erroneous, or you just, or challenging them, period, and you're saying we can review them de novo?
I'm saying, at least with regards to the documentary evidence, there can be a de novo review. We are arguing that it is erroneous in terms of there are gaps in these findings. The findings are incomplete, that they ignore and fail to address significant portions of the record, both testimonial and documentary. So we would suggest that that is where we get into the erroneous and the abuse of discretion. And specifically along those lines, with regards to the particular documents here, which is where the motion judge focused, near exclusively her energy in making the determination, the motion judge essentially, speculates as to the nature of those documents. Says there's a fax cover sheet in there, ergo the fax must have been sent. There's no transmission report. There's no additional evidence to support what happened with that except for its existence in the file. Similarly, but
is there any evidence when it was even written? I mean, I know it has a date on it.
There isn't. We don't have any additional evidence in the record.
There's no testimony.
No.
Who wrote that?
There's
whether
not.
it was written on the day that the date's there, right?
There is not. There is nothing additional provided about that. The judge says that the natural inference is that it was sent. I would suggest that there isn't anything. The record is silent as to what the files that were provided by the district attorney's office on that point. Similarly, with respect to the so-called wet signature, this is again just a document that's in a file. We don't have anything additional as to the fact the motion judge finds the natural inference again was that this was not sent. I would suggest that actually the record this is when we start broadening out our aperture and our view from these documents. We start looking at the additional omissions of the record. This is where I think that this comes into clear focus.
Before we go too far down that road, is there anywhere in the record that gives a reason why the victim would know that the defendant's underpants on the day in question were blue and white bikini style?
Certainly that could have been testimony that could have been used, at trial. It's certainly one factor in terms of the second prong of the Scott analysis in terms of looking at first prong here. I think that, that evidence right here has to do with that evidence is certainly in the record as said. But what we're looking at here for the prosecutorial misconduct angle and here whether or not this plea was voluntary was what the defendant knew with regards to he said at some point that he had saggy pants. That's one possibility that was in the record. But the other points here are that what did the defendant know with regards to the DNA report? And when we start looking at the additional parts of the record here, there are a couple of different things that we suggest that are in abuse of discretion here and what the motion court failed to do. We'll start with, when we look at the trial files, the discovery receipts, and the timeline of this particular case, I think it helps clarify. So on February 29th of 2000 is when ADA Pisano learns of the results from Cellmark, from the DNA testing results. And I won't go and belabor the record, which goes into the detail of why we think that those are omissions and those are noteworthy errors. And I would say that my brother in his brief contends that though he agrees that several of those were errors. But she gets that information there, and the Commonwealth has a case progress note in its record appendix.
Can you give the date again of when she learned of the DNA results?
February 29th of 2000. So in the Commonwealth's record at 77, there is a case progress note where this is ADA Pisano, sort of writing down her.
Sorry, to cut to the chase. On 229, I told Scott Skolnick the results of DNA.
Yes.
Right. So there's an oral conversation. I told him the results of the DNA. Right. So we can. I think your point is we can infer that there was a conversation about the substance of the DNA report. And so then the question is, when you document 6 days later, on March 6th, in a letter, whether you send it or not, if you put in there a summary that these records show that there's a high likelihood that her DNA was on his shorts, that's what she told him on February 29th, right? And so it doesn't, am I right about that?
Yes.
And
yes.
That's your argument? And
yes.
So it doesn't matter whether that letter was sent or not sent, or maybe it matters some, but what really matters is if for determining egregious government misconduct is whether she told him that on February 29th, right?
Correct.
Okay.
And my point for just pointing out that document at 77 is it shows that she has a misapprehension or is misrepresenting the DNA results as early as February 29th, because in her notes, that's when she says, in there, it's a little bit cryptic, but says his DNA on DE, the complainant.
Right. I want to back up and just put a point on this where we are analytically, doctrinally. The Scott framework. This judge chose, she had two issues. Was there egregious government misconduct? One. And then two, if there was it material? The judge could have bypassed that first prong and discussed the materiality of that egregious government misconduct, but she chose not to do that. She chose to rely exclusively on the first prong. And the second prong obviously requires facts.
Yes.
We can't make factual findings.
Correct.
So we're forced by the judge's analysis to focus entirely here in this appeal on the first prong, whether this was egregious government misconduct, right?
I would correct.
We're not allowed to contemplate whether that misconduct resulted in a material prejudice to the defendant, right?
Correct.
Okay. Go ahead, sorry.
No, that is
That's
correct.
helpful.
You don't think that, given that the judge credited the affidavits of Attorney Skolnick, that if they say it was material, it was material?
I think here what happens is specifically there are obviously two affidavits from Attorney Skolnick. One of the other issues that we're saying is an error here is that the judge, he then testifies, Attorney Skolnick testifies at trial, does not reconcile why in January of 2023, Attorney Skolnick, provides a very detailed and lengthy affidavit, and then, 10 months later
You
after he
think
joins-
the affidavits contradict each other?
I think that they don't necessarily contradict each other, but the judge does not reconcile why, 10 months later after after Attorney Skolnick becomes ADA Skolnick, why his memory suddenly, sort of dissipates.
Although if Justice Wood is right, I think the second one is only about receiving or not receiving the letter, receiving or not receiving the DNA report, and if Justice Wood's suggestion about what you're arguing is correct, then that might be immaterial given the representations on February 29th.
And the conversations that happened after that point, and then the letter.
Okay, but you don't, he said you don't need the letter. You just said the letter is part of it.
Well, I would agree with Justice Wood that the letter, whether it was sent, is sort of immaterial. I think the record evidence suggests that it was sent, or certainly
Okay,
is neutral.
but
I
we
agree
have a
with- I agree
finding
with
of
that
fact
point.
that it wasn't.
But I agree with that point.
Okay.
Yep. And finally, the judge does not make any findings with regards to the defendant's testimony. And this is not a situation where it is just sort of implicitly denied. There are parts of his testimony which are entirely consistent and corroborated corroborated by Attorney Skolnick's own testimony, such as him saying, I didn't know about this DNA report until 20 years later when my screening attorney gives it to me. Once my client gets a copy of it, he calls Attorney Skolnick and challenges him and says, why did you sell me out? And Attorney Skolnick tells him, I didn't do that. The DNA, your DNA was on her, that's how it was. And he says, he challenges him, and Attorney Skolnick comes in and testifies, yes, that conversation did indeed happen. The judge is entirely silent, does not address any of the defendant's testimony. With the time remaining, and the court's permission, I'd like to transition to the attorney-client privilege issue. This is a...
Right before you do that, though,
Certainly.
so what are the gaps? You said there are gaps in the findings, so that one is an express consideration of the defendant's credibility, right? That's a gap.
Yes.
Are there other gaps?
The gaps are failing to review or discuss any of the discovery receipts or the timeline. Every item is bait stamped in the record with regards to, except with this DNA report. We have the case notes that I referenced earlier. Also, her failure to reconcile Attorney Skolnick and ADA Skolnick's affidavits while only crediting the latter and saying, well, it was 20 years later, we understand, time can take a toll. It doesn't explain why 10 months earlier time had not taken its toll. So we
When you say the gaps, one of the things you just listed was the case notes. I mean, concretely, I think what you're saying is the judge doesn't address at all the substance of the conversation that the ADA had with defense counsel on February 29th. And we know, or we can infer from the letter whether it was sent or not, and therefore it is relevant.
Yes.
It's relevant because it helps us understand that conversation. There's no finding about what the substance of that conversation, right? That's the biggest gap, right?
That is correct. Yes, exactly
Okay.
correct. With regards to just briefly with regards to the attorney-client privilege issue, I don't want to belabor, as we did in the brief, the importance of this particular privilege. These communications, in this case, were not put at issue. The Commonwealth's position, and I think that was adopted by the motion court here, was that, once a motion to withdraw a guilty plea is filed, it is sort of open season on attorney-client communications. And that is, even if it is more limited than that in scope, though there was no limitation on the inquiry here, that is incredibly concerning for all of the reasons that we set forward in the brief.
Your client testified or put in his affidavit that he pleaded guilty based on conversations with his counsel about the DNA results. So why doesn't that open the door to the other factors that they may have discussed that influenced his decision?
Because the case law is clear that, first of all, the communications at issue have to be integral to the determination of the motion. The whole mixing in the whole sword and shield aspect of this. This was not the communications as to whether or not my client, specific communications as to whether or not he had committed the offense, were not put at issue here. We took great pains to limit the focus to whether or not the report had been received, whether or not its information had been transmitted to the defendant in this case, and we tried to limit that as best we can. There was no claim of ineffective assistance of counsel here.
But I think their argument is, even though you made an effort to do that, and you had a right to make an effort to do that, you didn't, based on the language of his affidavit. So why are they wrong about that?
And I would contend that would be incorrect. I think that the limitations that we put forward here with regards to the communications, we did not put at issue, again, this is not an ineffective assistance of counsel claim. All the cases when we see like Woodbury or any of the other cases, they're either civil, Bronner and Valley, or they're like Woodbury, where even in those cases where you're claiming ineffective assistance of counsel, the courts are very, very circumscribed in terms of their approach to what they allow in terms of communications. Here, when when my brother was asked by the court, what do you expect the result to be to the questions you're asking, he said, I don't know. This was a broad-based fishing inquiry into what the communications were. They were not limited to the specific issues that we raised in this case with regards to the information that was transmitted between ADA Pisano to defense counsel and what defense counsel then represented to the defendant before his plea. So we would suggest that, again, no implied waiver. There was, the communications were integral, and this inquiry was not in any way restricted.
Isn't this also all about materiality, the second prong? Why did you plead guilty? Because blank. That's materiality. That's the second prong.
Correct.
We're not supposed to reach that and query why the judge reached that if it's not relevant to her decision, which was based entirely on the first prong, right?
Yeah, that is entirely correct. And again, in terms of limiting the inquiry, that would have been an entirely reasonable approach in this situation. Let me make a determination as to first prong before we even delve into this. And as I've noted in the brief, this is a situation that I think is crying out for some relief here. The Commonwealth's position and the court's finding was that, essentially once these motions are brought, that they can, that this inquiry can be done. I would suggest, that is an incredibly dangerous road to take and would evade judicial review in these cases. We have tried from the very beginning to take this all the way up, but it was essentially, if not addressed here, it would evade judicial review.
Do you agree it was proper for the Commonwealth to ask plea counsel whether evidence of the purported prosecutorial misconduct would have changed his decision?
Yes, and I think we said that during the hearing, that we admit that there are some limited discussions that get to under that fourth prong of Scott Ferrara, but getting into the nature of these particular communications, I think, is beyond the pale.
All right, your time has expired, so unless I see further questions, which I do not, we will next hear from Attorney Locke.
Good morning. May it please the court. Michael Locke for the Commonwealth. The motion judge here did not abuse her discretion or commit an error of law in denying the defendant's motion. She held an evidentiary hearing, she heard from witnesses, she took evidence, and she made her findings based on evidence, none of which are clearly erroneous.
Do you agree that sorry, go ahead.
The defendant contends that the laboratory did not assign a statistical value to the probability that the victim was the source of the DNA in the defendant's underwear. Do you agree with that?
I do.
Okay.
I believe the report says that the victim could not be excluded using 11 of 13 loci. So there was a profile there. It appears that the last 2 loci on that profile there was an issue with it where they couldn't compare it to.
It's possible that 20 million people couldn't be excluded, right? We have
Sure.
no data at all.
Sure,
Okay.
sure.
All right, and you agree that the letter with the wet signature in the file misrepresented the strength of the DNA results and omitted that the defendant had been excluded from the sperm fraction found in the victim's underwear, right?
I do.
Okay. So the contention seems to be that there was a conversation prior to the date of the letter. So why isn't it natural to think that those misapprehensions or misrepresentations about the strength of the DNA results were communicated in that conversation?
Because on the wet letter, there's also a handwritten notation that says, spoke to Scott Skolnick, the defense attorney. It says this will be a plea, and it's dated 3/7. So now we have a future date where we now have the lab report, which I believe is dated March 4th. We have a second conversation, obviously, that occurred where we now have the lab report, and at the hearing, Attorney Skolnick actually testified in Volume 1, page 26, that he believed he may have received the DNA reports, but he just can't remember. So the issue here...
I'm not sure. I mean, we'll talk about why that might or might not make a difference. Do you think that there's anything contradictory in the 2 affidavits?
No, I don't think there's anything contradictory. My reading of his first affidavit, to me, it appeared to be rather vague.
Okay, so if there's nothing contradictory and everything is true in both of them, he says, I have it here somewhere, he says, before our appearance that date, I spoke with the defendant about the Commonwealth's case, including ADA Pisano's representations about the results of the DNA testing. He then goes on to say, I relied on ADA Pisano's representations as to the results of Cellmark's forensic testing in advising Mr. Andrews regarding whether to accept the Commonwealth's plea offer. Mr. Andrews relied on my statements relating to ADA Pisano's representations about the testing results in deciding whether to plead guilty in the case. Now, the second affidavit says he doesn't know if he got the letter or not. It does not say he didn't get any representations. If he did, then this would be perjury, which I'm sure your office doesn't want it to be since he works there.
He just for the record, he doesn't work there.
All right.
He's
well,
retired.
He did at some point, at this point. Who cares about the letter? She made representations to him. We can at least presume maybe it's not true, but it seems highly likely they're the same thing that is written in the letter. And he and the client relied on them, and you've said that they're false. Why isn't that the end of the case?
Because, again, the wet letter had the date on it that there was another conversation.
I don't understand what that has to do with it. She had heard the results and said what they were on the 29th. He says he relied on that before entering the plea on the 7th when talking to his client, and that his client relied on it in deciding to plead guilty. And if, in fact, I mean, you can say, well, but he had the report itself. So I guess I'd say 2 things about that. One is he couldn't have gotten it before the 6th because that's the day it was sent from Cellmark. And who cares? He should be able to rely on a prosecutor's representation of what's in it without having to flip through it himself. I mean, a careful person would, but still. So my question remains, why does it matter? So let's agree, or for purposes of argument, that the letter was not sent and that the other thing was faxed. But he's not saying he relied on the letter. He's saying he relied on representations.
Again, on the letter, there's a date where they had another conversation.
Yes, where he, meeting her deadline, so that it wouldn't be a 5 to 7, it would be a whatever it was, 2.5 to 3.5 or whatever. He calls and says, yes, we'll take your deal. But that's after he has talked to his client who's decided to take the deal, presumably based on, well, not presumably, he says, based on these misrepresentations.
I apologize, I don't recall, in Attorney Skolnick's first affidavit, does he say the date when he talked to Attorney ADA Pisano? Because I think he just says representations, which could have been at a later time.
On the 7th.
It says,
It would have to be on the 7th, right? Because he could have, you say, gotten this report on the 6th, which I don't know, but maybe he did. Maybe it came right into the ADA's office and she immediately faxed it and he had it that day. But he couldn't have known that her old representations were wrong until that time. And I'm not sure it matters whether he looks at the report or not. Once he's been told by the prosecutor, there is an infinite likelihood that that your client did this.
I apologize, Your Honor. I still think that, again, there was obviously a second, even if, assuming that first conversation, wrong information was given, there was a second conversation after the DNA report came in.
Yeah, so let's just, let me take a different stab at the same thing.
Sure.
I'm going to read the entire note from that 3-7 conversation. 3700, spoke to Scott. This will be plea on 310. That doesn't tell me anything about the substance of that conversation. What tells me something about the substance of the conversation, though, is the letter that it's written on. And I'm trying to get my head around your contention that she would have sent him the report, which contradicts her description of the report in the letter. In other words, why would she write in the letter the following? The statistical probability that the DNA belongs to victim is incredibly high. That's actually not in the report. So why would she write that if she had previously sent the report? The only inference is that from the fact that she wrote this, again, whether or not she sent this letter, the fact that on March 6th she types this out, the only rational inference is that she did not send the report, and she's misrepresenting, either intentionally or unintentionally, because she doesn't understand it, the substance of the report. How do you get around that obvious inference?
I apologize, but it sounds like this court would be fact-finding at that point, and we have findings from the motion judge here.
The motion judge credited the testimony of Attorney Skolnick, which includes this first affidavit, that based on these representations, his client chose to plead guilty.
She credited his testimony at the hearing. I don't believe she said that she credited
So you think she discredited his affidavit?
She did not say either way.
Okay, but do you think his testimony at the hearing contradicted the affidavit?
His testimony, I believe he no longer remembered as to the conversations. And it appeared at least less detailed, his testimony at the hearing.
Can Justice Rubin quoted something, I'm quoting something different, which I think is clearer. Record Appendix 82, this is his Attorney Skolnick's affidavit. I did not receive or review the forensic testing results, reports, or supporting files before Mr. Andrews offered his plea. Before the Hampton County Superior Court, period. That seems to me emphatic and clear that he did not receive the report. And then suddenly, after he's taken a job with the Hampton DA's office, he's not sure. He doesn't say, I did receive it. He says, now I don't remember. But his affidavit is emphatic that he didn't receive it. And so the judge's finding based on that is very problematic to me. But also, her finding, we're allowed to make conclusions that they're clearly erroneous. And so it's not beyond our power. Admittedly, we have to find that they're clearly erroneous. There's deference. What I'm asking you is, why is it not clearly erroneous, given what she wrote in the letter?
I'm looking at Attorney Skolnick's first affidavit. It's record 82 at 11. He says, to the best of my knowledge, ADA Pisano never provided me with a copy of Saltmark's forensic testimony.
Read the next sentence.
Keep reading.
Right, I did not receive, but he couches it first, to the best of my knowledge.
Okay, well, let's say we disagree with you about that.
sure.
Let's say, hypothetically, that ADA Skolnick had a conversation on February 27th. Let's say it was clearly erroneous to suggest otherwise, and in fact, there was no finding at all about what the conversation was. So that's a problem for your case. But assuming we believe that the conversation was, I've got that Cellmark report, and the Cellmark report ran the pop stats, and your client's DNA, the victim's DNA is in your client's underwear. That's bad for you. And let's agree we think that was either a lie or just mistakenly wrong. Is that misconduct, and is it egregious misconduct?
If that were all true, then if it wasn't cured, then yes, I think that would be misconduct, and egregious misconduct for the first stage of
So
Scott
you're
fraud.
saying if she, I have no idea what the facts are here, but if she misunderstood the DNA reports and she conveyed her misunderstanding, that would still be egregious misconduct?
This, again, is the problem, is that we're assuming facts because we don't know. Obviously, if it was intentional, then yes.
Okay, but even if it was
But
a
I'm
mistake.
asking if it was
No,
a
go ahead.
mistake.
I believe there's some case law that says slipshod performance is not bad enough. But here, I think, based on the representation, I would say that it would be.
I mean, you've got, as a matter of due process or something, you must be entitled to withdraw a guilty plea that's based on even a negligent
Sure.
misrepresentation of a critical fact.
Yes.
I would think. I don't know
I
what
would
the
agree, yeah.
rubric is, but I don't know how you can avoid that conclusion.
And also, to the extent that there's a cure, because I get, hypothetically, they have this conversation, it goes the way I just suggested. She then sends him the report, and even though the letter explaining the report is the opposite of the report, she still sends him the report, showing that her letter is wrong. I don't know why she would do that, but let's say she did that. I've lost my train of thought.
Even if there was a cure.
If the conversation was the same, as you said, we were asking about whether it's
Is that,
egregious misconduct.
to the extent that there's a question, to say, backing up, if that could be a cure, there's still this other evidence that your opponent cites about on the factual question of whether the report was sent. The judge relies on the waffling testimony of ADA defense lawyer Skolnick, but she ignores the bait stamp and the discovery practice. The discovery practice is good here in that it gives an itemization of what we've given you, and it stops right before the Cellmark report. The judge doesn't address that point at all. They were bait stamping all discovery to prove to the defense counsel, as a responsible prosecutor is supposed to do, everything they were giving him, except right before the Cellmark report. And then suddenly, we don't have any proof that any documentary proof that the Cellmark report was sent. Am I accurately characterizing the record, first of all?
Yes, I believe so.
Okay, and I'm correct that the judge didn't respond to that at all, right?
That's correct, Your Honor.
And so that undermines the reliability of her finding as well, doesn't it?
She did not make express findings on it. I don't think it cuts the reliability of her findings. She found what she believed to be true. She had the hearing. Again, it's the defendant's burden here to establish that this happened.
Do you agree with me that what I said to your opponent, that we're not allowed to get into materiality here because the judge chose this path? She chose to rely entirely on egregious government misconduct prong, and so we're not allowed to contemplate whether this would have made a hill of beans a difference in the end.
I do, Your Honor. I think if you were to vacate, you would have to remand it back.
Right. Okay.
I have a couple of questions. If you continue on in paragraph 11 on record 82, the first sentence says, "to the best of my knowledge," right? But no sentence after that is modified. If there's an unequivocal statement that he did not receive or review the forensic testing results, right? Are you saying you think that's still to the best of his knowledge and you don't think that's just an unequivocal statement?
I don't know how he can say in the first sentence, to the best of my knowledge, and then say definitively.
Cellmark might have sent him the report too,
They could have, yeah.
right? So the first one would be, I don't know if she provided me with a copy of it. But I didn't have one before, at the time I talked to him about his plea.
That's true, that's possible. But again, this was an evidentiary hearing with the motion judge and her
Right,
findings.
but then there's another sentence where he says that the defendant did not review the forensic testing reports. There's no equivocation there unless we import, to the best of my knowledge, to that sentence. And then he says, I relied on her, ADA Pisano's representations as to the test results.
Again, whether it's qualified to the best of your knowledge of the beginning, I believe that
Okay.
he clearly did not have a good memory of what happened here, and that was qualified as to the rest of the statements in that paragraph.
All right, and then he says there are gaps in the findings that the judge doesn't deal with the case notes and the substance of the conversation of counsel. What do you say to that?
That the judge didn't find them noble enough to make findings on them. They were obviously in the record. They were argued. She found the evidence before her that the defendant had failed to establish that there was egregious misconduct here.
Okay. I see no further question. I have one. I'm not going to make it a question. I'm just going to say it. I was concerned about this second affidavit. Obviously, there are aspects of obtaining it that may bear on its credibility. But as you know, there's a rule of professional conduct that prohibits a prosecutor from participating in a case in which he was defense counsel previously. And I just wondered, and it's just something for you all to think about, I just wondered if he should have written an affidavit in support of the Commonwealth, given that he had been the defense attorney in this rule of professional conduct, or whether maybe he should have said, look, I'll go and testify, but I'm not participating. So, I don't know. All right, thank you very much. These are excellent arguments by both of you. Thank you very, very much. It's an interesting case, and it is submitted. Our next matter is number 25-195, Commonwealth versus Zapata. And we will hear first from Attorney Driscoll.
Good morning, and may it please the court. Attorney William Driscoll for ADRIAN Zapata. This case is controlled by Gonzalez and should find that there was a grievous error, structural error here, requiring a new trial. Gonzalez is supportive of both prongs, even though they were not directly on point with this case. Zapata used Green and Roach to address the issues of this case. In Gonzalez, the judge used an inadequate for-cause standard on the adequacy prong and sought Green, which analyzed the for-cause as being inappropriate in a preemptory challenge. Now, the reason for that is preemptory challenge is not looking for prejudice of the juror. It is looking for subtle biases, completely different avenue here being examined. Yet the judge below decided that Juror 59 could be seated, even though there was no race-based, it was a group-neutral reason specific to that juror, that he had found her indifferent and able to receive the evidence without bias.
Well, he actually says two things. So let's start at the beginning. This is under the genuineness prong.
Yes, it is.
Because the judge says it's adequate, and it looks adequate to me.
Yes.
Okay. So genuineness means, is that really why you did this? Right? You've got an adequate reason, but is that why you did this, or did you do this because of race or gender or other protected categories?
Well, I'm sorry. He did not use it because of race or gender or any other inappropriate category, because the judge explicitly stated as much in the adequacy prong. So the judge could...
No, the adequacy prong is only about whether what he articulated was based on race or gender, because sometimes something that someone thinks is race neutral may in fact be a proxy for race, or maybe so disproportionate based on race that it really isn't adequate as a race neutral explanation. In the adequacy prong, all he can say, and I'll look again at the text, of course, of exactly what he said, but all he can say is, that is a race neutral explanation. And if that were the real reason you struck this person, that would be adequate. And he says, oh, her participation in working after college in this organization, making contact with victims of domestic violence or sexual abuse, I don't remember which, that's an adequate reason for a peremptory strike. Then he turns to genuineness, right? But is that really why you did it? Is it genuine? Now, he could have said, I find it's not genuine because I watched you as you told me it, and it's clear to me that you were just making that up. So I don't believe you. You're not credible. And, okay. Or he could have said, it's an adequate reason, but in this case, it was 48 years ago. And there's no, I don't know how many years ago it was actually. And so I don't think it's plausible that that's really what's concerning you now. And so I find it's not genuine. He didn't quite say that. He did say something garbled about all those years ago or something decades ago, but then he goes on to say, and she didn't appear prejudiced to me. She appeared impartial to me. But he said genuine. I'm not sure, I mean, does the fact that he said all those decades ago, does that do anything to make this different from him simply saying, no, she seemed impartial to me?
Not at all. And Gonzalez addresses that point of this prong through Roach. In Roach, there was a African-American nurse who was peremptory challenged. And the reasoning there was, there's a lot of medical evidence in this case, and I want people without medical experience. The judge found disbelief. I don't think that's your reason. I think it's race-based, so I'm disallowing it. Roach said no. And not only that, the disbelief could not be inferred from the record. The disbelief cannot be inferred from this record either. Now, the two
Remind me,
reasons-
I think in Roach, there was, I could be wrong about this, but there was no finding, no explicit finding. Was there an explicit finding about genuineness? I think you're lying or something like that in Roach. Or was it I think part of the problem may have been that there was no finding at all about whether it was genuine.
Exactly, and that's our stand, is that there is no finding of genuineness in this case.
All right, well, so let me read the actual transcript here. Justice Rubin was trying to recollect. It's 147, Volume 1. I find that it is not genuine, that the witness's work on Sirius decades ago, there's nothing in her answer or her demeanor that suggests that she's unable to completely fair to Mr. Zapata and completely fair to the Commonwealth. And so I'm going to overrule the exercise of the peremptory and turn to the Commonwealth. So I think there is, if the problem in Roach, and I could be wrong, was that there was no explicit finding on genuineness, it seems that here there is an explicit finding on genuineness. I think you're lying. I think that the reason you want to get rid of this person is because it's a white woman. That's what he's saying, and you can't do that.
And I disagree with that on the basis of Roach.
Okay.
which says that you cannot infer from the record. Now, the two reasons given by the judges here was, I found her indifferent, and the sex assault victim experience was too remote in time. Both of those have to do with whether or not that juror could be impartial, which is the for-cause standard. So the judge's genuineness prong was based on for-cause standard.
Well, I'm not sure I agree with that. If the judge is saying this happened a really long time ago, over 40 years ago, that's, I think, his way of saying, I don't believe that that's what you're worried about. I don't think I mean, we could disagree about that, but he could say, I don't believe that that's what you're really worried about. I think you're worried about the fact that she's a woman and this is a rape case and she's white. I don't quite know why, but okay. So that's what the judge seems to be worried about. In other words, the point is, just because that bears on genuineness, that citing, the judge's citation to the fact that this happened 40 years ago seems to bear on the judge's finding that this was not genuine. What do you say to that?
That defense counsel, I believe, made it clear that the reason why he is challenging is because juror 59 had experience working with victims of sexual assault.
He says that. I get it. He says that, but the judge seems to be making a finding that he doesn't believe that. Or is it he? It might be a she. The judge, I can't remember.
Is a he.
Is he? Okay. Anyway, sorry. But if the judge is, if let's just assume I'm right, that the judge is making a factual finding that I don't believe you, that that's not the reason, is that adequate under Gonzalez?
No, it is not. It's not adequate for the genuine standard because he's making a personal judgment that he would make on a for-cause basis. I believe that someone that worked with victims of sexual assault 20, 30 years ago is perfectly capable of putting their life experience behind them and not considering that as a factor in this case, which is a rape case and a assault and battery on a family member. That you're experiencing, listening to what victims of sexual assault went through, your experience as a woman listening to that would have absolutely no impact. So forget your experience. Don't bring that into the deliberation room because it's too old.
I agree that there's space for a reasonable disagreement about that.
Yes.
But I think the law, tell me where I'm wrong on the law. The law is that the judge has to make a factual determination, and we give the judge discretion here. We review this for discretion and an abuse of discretion. The judge has to determine factually, is that what you really think, or do you really think you want to get rid of women, and white women specifically? And if the judge's conclusion, bolstered by the fact this happened a really long time ago, is reasonable, that we have to affirm it for not being an abuse of discretion. Where am I wrong in stating the law there?
If the judge made the same genuineness finding on a rape victim because she was raped 20 or 30 years ago, would that also be permissible?
But I thought, in terms of the law that Justice Wood is talking about, and I always presume he's correct. So he doesn't. You don't even have to preface things with that anymore when you talk to me. I thought there was a case that said the judge can't just say it's not genuine. The judge has to give an explanation for why it's not genuine.
He does.
So if he just I find as a fact not genuine, inadequate. So then we look at his explanation. Now maybe it should be read the way Justice Wood is saying. But on the other hand, and I want to leave the phrase for cause out. I understand it's a test that's used in a for-cause challenge. But the problem I'm having isn't that it's the test that's used in a for-cause challenge. It's that the point of peremptories is to get at subtle bias. And for whatever reason, we allow that. Not with respect to race, ethnicity, gender identity, sexual orientation, but with regard to anything else. my upstairs neighbor was a cop for a long time. He was a good guy, or whatever, right? That even though the person appears impartial, the defense counsel can say, like, look, I'm going to use that. I know I can't get it for cause. I'm going to use a peremptory. And if the judge says in response, that's not genuine because he appears fair and impartial, it's inadequate because, of course, he appears fair and impartial. It's a peremptory challenge. It's used on people who appear fair and impartial, but who nonetheless, for both sides, counsel for either side can say, yeah, I don't want that person. If it's for an improper reason, that's one thing, but otherwise, that's it. I mean, it seems to me that that's the problem here. Why is he talking about how she appears at all? Of course she appears fair and impartial. You can't deny someone their right to, that doesn't make what the person said not genuine. It can't, because every peremptory challenge is used on that kind of person.
I believe the line of cases you're looking for is in footnote 8 of Gonzalez. And one of those cases, mentioned by the Commonwealth in the brief, is Curtis. There, the only black juror in the veneer was challenged peremptorily. The juror's wife worked for DSS, and it was a sex assault case. But the juror did not work, was not an employee of DSS, and there was no child involved in this case, which was a rape and indecent assault and battery case, and no DSS involvement. There, the genuineness reason was a bit obtuse. And what the court says is, yes, you have to come out and say whether or not it's a scam. However, in this situation, the judge's writings as a whole said, look, this isn't a DSS case. There's no child involved here. This is an adult sex case, and you're talking about the person's wife. Well, to that point, the dissent I'll bring up in this case said, I don't see any difference there between letting the peremptory go through here when we allow it when people's family members are police officers. But that was a dissenting opinion. But in that case, they said, based on what the judge did say on the genuine prong, we're going to allow it because it was clear that he meant to say, I don't believe you, there's no DSS here, that's just not the reason. But in this case, we're talking about a rape case of the man's wife, and you're also talking about a woman who had worked with sexual assault victims. Clearly on point, not, my husband had a girlfriend that got raped 20, 30 years ago. This was directly on point in her personal experience.
I guess what I'm wondering when I look at this transcript page is when it starts out with the judge saying, this is the 4th time you've sought to exercise a peremptory challenge for a white female prospective juror and asks for the race-neutral reason, must we, can we, are we prohibited from importing that into what follows at the end of the page, where he says, I find that's not genuine?
No, because he also found it was not race-based and it was not gender-based. But what we do know is defense counsel's strategy was to eliminate anyone with direct hands-on involvement with sex assault victims. 2 people that had...
this whole debate in the briefs about this seems completely beside the point to me. No one said that was the reason at the trial, and the judge didn't rule that was it seems an adequate reason to me. But, it's not even clear that he remembered the 3 other people who had I don't know if it was you or somebody else, the defense lawyer doesn't say, this is so different from those other ones, doesn't mention them at all, may not even remember them.
Oh, it's pretty clear to me that he didn't remember.
All right, so sitting here and saying that the genuine reason was this one had hands-on experience and these ones different, He didn't say that. That's not the reason he gave.
No, we would talk about his strategy. He allowed onto the jury two people with tangential.
And if he had said, I have allowed onto the jury people with experience before, but they didn't have hands-on experience, right, then we'd have a different case. But he doesn't say that.
But that is his strategy for
I
choosing
don't
a
know.
jury.
It's your post hoc rationalization for his strategy. I just don't know. We don't know if it's true or not.
It's in the transcript, Your Honor. That's the strategy he used. He eliminated two people with
In the
direct.
you're saying you infer from what he did. He doesn't say. To me, there's a huge difference between
Oh,
hands-on.
he didn't say that
No, he
during the
didn't.
peremptory challenge, but it's clear from reading the transcript that he had a strategy of, okay, here are two people with sex assault organizational tangential. A girlfriend went to a
Well, we'll have
survivor's
to look at
meeting
that.
once.
Your time's expired, but if there are further questions? No? I see none. Thank you very much.
Thank you, Your Honors.
We will hear next from Attorney Kosh.
Good morning, Your Honors. May it please the Court. Kyra Kosh, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. I'm asking this Court to affirm the defendant's convictions as the trial judge properly determined under the correct standard that the stated reason for the peremptory challenge was adequate but not genuine. I agree with Justice Rubin that I think the main issue is whether the judge abused his discretion in finding that the challenge was disingenuous rather than whether the proper standard was used. To distinguish Gonzalez,
But the judge does seem to say that she's impartial, and that's why his reason is not genuine.
Well, the reason that defense counsel gave was due to the juror's volunteer work, and that directly speaks to her ability to be a partial juror or impartial juror. So the judge is entitled to say, well, based on my assessment of her demeanor and her answers, that I believe she could be an impartial juror, and in fact, that is not the reason for the challenge.
That doesn't sound right to me. Right, because of course she doesn't appear impartial. Many times peremptories are used after a for-cause challenge where the judge has said out loud already, I find her fair and impartial. And then the person says, well, I'm going to exercise a peremptory then. And if there's no allegation or basis for thinking it's racial or gender-based or so on, they get to do that. And the reason they get to do that is maybe there is something that indicates a subtle possibility of a subtle bias that hasn't been exposed here, right? So the judge simply saying she appears fair and impartial, that's where we start. That doesn't make the idea that there might be subtle bias on a non-gender or racial basis not genuine.
Correct, but it was the trial judge's assessment of the defense counsel's basis for the challenge. He did not find it credible, not genuine, that was in fact the reason for the challenge.
Why was it not credible? That's what we're asking, right? Because there is some cases that say you can say adequate, you can say genuine. You got to spell out, why. You can't just say I find it adequate but not genuine. You have to say why you find it not genuine.
Yes, and I believe the trial judge correctly did that here, where he said there's nothing in her work, like that volunteer experience, which was the sole reason provided for the challenge. He did not believe that was.
Well, he said based on her demeanor and her words, right?
Well, I find that it is not genuine that the witnesses' work on Sirius, blank, decades ago, there's nothing in her answer or her demeanor, blah, blah, blah. I mean, I think it's not a lot, but I mean, so the case law does require a finding of factual support for the finding of not being genuine. And there is this statement. I think you have to breathe a lot of air into it. I think what the judge is saying there, and this is dangerous to do this as an appellate court, is the judge is saying she did this work. I don't think your citation to this work is genuine when it happened 40 years ago. The judge is saying, I think, this span of time means that that's not really why you are striking her. That's what you're saying, right? But,
Correct.
But isn't it a problem, I mean, to play, flip it over, that's very little, there's no more. Is it a problem for you that there's no more justification? And I had to work so hard to breathe life into that explanation. Is that good enough?
I think it's good enough, and I think this case is controlled by Oberle, 467 Mass 539, where the judge said, as to their findings as to genuineness, I think the defendant and counsel are seizing upon the background of this particular juror, just like in this case, and the judge said, I am not persuaded that this is anything other than a pretext, respectfully, and I think it's an effort to keep females off the jury. That is almost the same as what Justice Salinger said below here, although he didn't explicitly say it was a pretext. He said, I find it's not genuine.
It's a pretext if it's not genuine.
Correct.
Right, obviously. He's saying, this is why I did it, and that's not why you did it. That's a pretext. I mean, those are the same thing.
Correct. And so in Oberle, the SJC affirmed the denial of the peremptory challenge with just those findings, even though the judge didn't even explicitly state, I find the reason adequate, as Justice Salinger did here, and made the proper finding because it's not based on the individual's membership in a protected class.
I gather nothing was done to reconstruct the record so that we could understand what the word serious, which obviously isn't the word he used, or whatever was in the bracket after that was, which seems possibly essential to understanding what the hell he was saying. Is that right?
Correct. I'm not aware of
Now,
that.
there's a couple other places where the court reporter has used the word serious, and it's clear that he or she means Suarez. Do you think that's what this means?
Potentially.
It'd be a weird place to put the word Suarez, but
I agree. I'm not exactly sure what it says. I haven't listened to the FTR myself. But
do we have that?
I'm not sure. I'd be happy to.
Is it in? It's in the record.
I don't believe it was added to the record.
Well, I don't mean the record here. I mean the record below.
It should be, yes.
Interesting.
I'm sorry. I'm not.
Yeah,
I'm not completely aware.
I'm not completely aware if we're supposed to have that or not. I don't know what the rules are. If you look into it and we can have it, then
I can
obviously
certainly
we'll figure
look
it out
into
for ourselves too. If we can't, we won't look at it.
And
Sure.
obviously, if you all agree, that would be helpful if you let us know.
Yeah, could maybe consult with each other about that.
Could I pivot to another aspect of your argument? There are two male jurors that the defendant does not object to. They have some contact with sexual abuse organizations that highlight sexual abuse, or events really that highlight sexual abuse as a problem. It seems to me that those are, I don't think it's necessary, but I don't think that those arguments are compelling. So I want to give you a chance to respond to that. First of all, juror 19, or the weaker one, juror 22. His rugby team dressed up at school in dresses and high heels to promote Denim Day. I mean, this is obviously a very serious topic, but I think that is not analogous to manning or womaning a rape crisis center where which I think is what's going on back in the 80s, when she's talking to victims of sexual abuse and providing a private conversation, which is very intimate and serious. This is not the same thing. And so it seems like it's not appropriate to say that, well, if he allowed the man who did this, he's really just trying to strike women. Are you following what I'm saying?
I agree there is somewhat of a distinction there, but when trial counsel was first asking the judge, I want you to ask the veneer a question regarding whether they have any experience with sexual assault victims, the way it was phrased, which is at transcript volume 1, page 9, was something along the lines of if they're a member of any groups or movements. He wasn't necessarily geared toward people who have worked directly with sexual assault victims. He was casting a wide net, if you will, regarding anyone who may have some subtle.
Okay, that's a good point. That's a fair argument, but I think the consequence is he just wants to identify them, flag them. And so now we're in the hurly-burly of jury selection. He's got to decide, okay, that's one factor. I want to know that factor, but how important is it given all the other factors? And when he hears this doesn't seem like it's that much of a problem. And I think, well, but so let's put that one off to the side. The next one seems a little closer, more problematic. This fellow went with his girlfriend to an event where sexual assault victims spoke in public. And so it's still different, I think. And so, but you're arguing that, well, again, same argument, the defendant seems to be okay allowing men who have worked in the space of sexual assault awareness, but not women, and so that's evidence that this lawyer is really motivated by sexism. Again, your argument doesn't rise or fall on this point, but I think that this point is not convincing to me. Tell me why you think it is convincing.
I mean, to me, I think someone who, it sounds like it was a multi-day event where the male juror was listening to sexual assault survivors tell their stories, and that was only 6 months ago. I think that would have a strong effect on a person of, wow, this is a real, experience versus someone who almost 40 years ago listened to people over the phone for a couple months in college.
Do we know how old the person is? You say it's almost 40 years. Do we know that?
She said, Juror 59 said it was either 1980 or 1981. Honestly, she wasn't even able to really articulate what exactly her work was.
Okay, this brings me to another question about this. So now I think the argument has to rest on that it was a long time ago. What difference does that make?
I just think it goes to potential impact it would have on her.
Okay, except it is true, people change their views over time sometimes. Sometimes newspapers report when someone changes their views about something. Used to totally support school choice, this congressman, but now doesn't, or whatever, because it's really notable. Lots and lots of people form their opinions about things like sexual violence.
Correct.
When they're in high school, maybe before, certainly by college. What does 40 years have to do with it? Do a lot of people who have volunteered at anything renounce their climate change thing, but now it's 40 years later, like, I know, oh, no, now I'm for fossil fuels? It seems unlikely, doesn't it?
I'm not saying that's the case, Your Honor, but I think that goes to the adequacy of the reason rather than the genuineness.
No, if the reason it's not genuine is it's a long time ago. I mean, I'm sure there's plenty we can think of, plenty of peremptory challenges for things a long time ago. Oh, you were raped, but it was a long time ago? Oh, you were a victim of an armed assault, but it was a long time ago? I mean, presumably we still want those peremptories to be exercisable, right?
Of course, and that might even rise to the level for a cause challenge given the circumstances. But when you look at all the factors from Sanchez in evaluating whether there's discriminatory purpose, most of those are met here. Prior use of challenges, every single peremptory challenge, 4 of them were against a white female.
But this is only about the genuineness prong because he articulated another reason that is adequate. If it's true, then he gets to exercise the peremptory.
Correct, and this court is not in a great position to make the finding of fact themselves as to whether they see it was genuine or not. Your Honors may not, if you were in the trial judge's position, might not have rejected the peremptory challenge. But here we have to give deference to the trial judge's determination as to defense counsel's genuineness of the challenge.
Oh, but of course, if the judge had said, I don't think it's genuine because it's Tuesday, and I get a lot of liars in here on Tuesdays, I've been doing this for a long time, right? We'd say, what? Like, that's no good. And now he's saying she worked on, I don't know that it's a rape crisis line, but she worked talking directly to victims who called in or something, it says. But it was 40 years ago, whatever.
Well, that was juror 39. 59, all she was able to say was, my job was just to be available to victims. I'm not even sure exactly what that means. It doesn't seem like she has much of a recollection herself. But again, I'm not...
She can't remember her views on sexual violence from college.
Well, that
I remember mine.
That wasn't exactly in the record, Your Honor.
So what, can you just, I feel like the judge didn't give us much to work with here. So what's your best articulation of why this wasn't genuine?
Well, I think exactly what the trial judge said. Again, it is very similar to what the judge said in Oberle, that this court said, well, the SJC said was sufficient findings as to genuineness, that the defense counsel was seizing upon the background of that particular juror, which the trial judge, in his assessment, did not feel was all that meaningful due to it being remote in time, and that they were not persuaded that it was anything other than a pretext to keep white females off the jury. And that is particularly relevant when this case is a serious domestic violence and marital rape case with a female victim.
What was the race of the female victim?
Hispanic.
Okay. But you also argue that the juror's experience was outside of Massachusetts, and I really didn't understand why that was relevant.
Well, I was just saying if she was in Middlesex County speaking to victims in the community, that might have more of an impact. But
She was in her community.
But I
It's
think-
the same for her.
But if she's sympathetic or I don't know if it's possible to be, but overly sympathetic to rape victims in California, then why would that make a difference if she's being considered for a jury in Massachusetts?
I don't think it really falls on that issue, of course, but just I think it hits closer to home if it was an experience that happened here.
Can I ask you, are these errors, if this were an error, never harmless? Never, even if it's beyond a reasonable doubt, never, there's no harmlessness analysis. If we find that this was an improper a disallowance of the strike, this has to be a new trial, is that right?
Correct, it's a structural error.
All right.
But again, I argue it's not a structural error.
Oh, I'm aware of that. I see no further questions. Great arguments, both of you. Thank you very much. Very helpful to us. One more and then a break. So, our next case is number 24922, Commonwealth versus Noel. And I am going to just alert the court staff and everyone else, I guess. We're going to take our traditional mid-morning break after this argument. So, having said that, we will hear first from Attorney Brooks.
Good morning, Your Honors. Benjamin Brooks on behalf of HELMDEAN Noel. May it please the court. This is a partially impounded case. So I am going to be doing my best not to mention any names. So obviously, this case involved intensely disturbing material, extensive testimony from a complaining witness about years of horrifying sexual abuse. But the defendant was entitled to a fair trial. And here, there were errors in foreclosing an avenue of cross-examination and denying a Rule 17 motion about the same issue that undermined Mr. Noel's ability to effectively challenge the Commonwealth's narrative of the case and the complaining witness's credibility.
So
Along one
I
of the
want to
few-
just, sometimes cases come to us and they're big and we can sort of cut them down a little bit so we can focus more on the issue. So are you challenging the victim's identification of herself? And I'm just using the word victim as a shorthand. I know you're contesting. Are you challenging the identification by her of herself in the videos?
Well, as part of the general credibility challenge, yes. Right?
Yes,
Because that was
okay.
part of what the defense counsel was trying to do here.
Would she have been under 16 for every conviction except for 15 and 16?
I believe so, yes.
Okay. So I know you challenge her credibility, but, and I believe that you've not given us any pictures or any of the video, correct?
I didn't include any of it in the record appendices, no.
Right, and I guess what I'm trying to understand, though, is that does that then end your client's case? Because the Commonwealth is saying that we could look at the still photos of her and her beauty marks, and the jury could and determine that was her. They also have her brother's testimony. And the jury could have looked at the pictures of his legs and compared them to the legs of the person in the videos and concluded that was him.
It's possible that the jury could have done that, right? But what we're assessing here is, first, with respect to the foreclosure of the cross-examination, whether there was harmless error under the Chapman standard,
Right, so I don't understand how
So-
we're in a position to do that, given that we don't have this very significant evidence.
Can I actually ask a preliminary question about
Sure.
that? So I don't mean to cut off Justice Henry, but I want to, because we don't have the photos, I agree absolutely with the drift of what Justice Henry's saying, that credibility kind of turns on the ability of the jury independently to make identifications based on other evidence. So the blotchiness of the defendant's skin on his thighs in medical records, that seems like a fact that we can hold on to. But I don't know, and then there's a video in which the rapist has, his skin is visible and it has blotchy thighs.
Supposedly, yes.
So if, I don't know how clear, I need, to cut to the chase, we need to see that to be able to figure out, to make the comparison, because then we need to figure out, could the jury have made this ID comparison? I'm not saying that ends the case, but that's a huge chunk of the case.
Wait, we need to see it if you contest it. If
Right,
you agree
right.
with them that
Right.
there's blotchiness in the video and blotchiness thing, then we don't need to see it.
Yes, I mean, I guess then I have sort of not provided something critical to the court. I felt that this was sort of, we were making this argument sort of based on his inability to challenge the defendant's
But the harmlessness,
credibility.
well, so let me ask you about that. And this, for me, covers both number one and number two. Okay, there's an allegation when the victim or complaining witness was 4 or something against her oldest brother.
Correct.
And you want to cross-examine her about that, and you want to see medical records or psychiatric records, I don't
Or
remember,
DCF records.
DCF records that might well refer to this. And the purpose of this evidence would be to show what?
The purpose of this was to challenge the Commonwealth's narrative of the case. And
You said that before, and if I can ban the word narrative from all public discourse, I
no more
would,
narratives.
because, I mean, okay, go ahead.
But and essentially it went to what the prosecutor says in her opening statement, which is that for many years, the complaining witness didn't didn't report this abuse because she, like many children, didn't understand that it was wrong at the time and sort of didn't have the capacity to do it. That's not an exact quote, but that's essentially what the prosecutor says in the opening statement. And then during the testimony, the complaining witness doesn't actually quite say that. She
No.
says, I felt like I was on his team, but it's essentially the same thing.
No, it's not,
So-
but
so-
she's not saying I didn't know how.
Well,
She's saying
not
I
saying
didn't
know
do
how.
it because I had a reason. I thought I was helping him, I thought, right, all this stuff.
Well,
So-
fair enough, it's not exactly the same. But the statement that I thought I was on his team, I think can be parallel to saying,
But I guess
I didn't understand that it was
and I want to
wrong enough to
get back
report
to,
at that point.
Justice Henry's question, but I guess I don't understand what possible difference this makes.
Well-
Okay, so what would it mean? It might mean when real sexual abuse takes place, she reports it. So she didn't report it, so it's not real. Or maybe that was a false allegation. She makes false allegations. There's multiple videotapes of this. If you corroborated by the brother saying things like, that's the mask he kept in his drawer, that's his voice, right? So what possible difference do these arguments make? How, this goes to harmlessness even beyond a reasonable doubt. How are you going to persuade the jury that she would have reported it earlier if it was real, so it's not real, when they're looking at videos of it?
Well, I would start by saying this, like, there is a distinction when we're talking about overwhelming evidence, and that's essentially the argument. Look, the evidence here was overwhelming, how can you show prejudice? Where evidence is overwhelming and it's emotional impact, and then overwhelming with respect to its ability to demonstrate proof beyond a reasonable doubt in a more sort of clinical way. And I guess this gets to the point you made, because how can you make that determination if we haven't looked at the videos themselves? But here, the evidence that was apart from the complaining witness's testimony was not overwhelming in that sense, we suggest. There was, we acknowledge, corroboration from the brother. He said, yes, I recognize my sister's body, I recognize the defendant's voice, I recognize, or there's a, the defendant had green-colored walls, although he never actually identified any of the pictures or stills from the video as that same green-colored wall. And then there was testimony from Agent Futrell that verified some of the things that the complaining witness had said about the dream board, the princess videos, the existence of the Tara video, and some of the salacious details around that. But most of the corroborating factors were details that the complaining witness gave to the jury, and the jury would have been required to sort of credit her in the first instance to find them corroborating. So in the first interview, the complaining witness says nothing about the circumcision, nothing about the scars on the body that you asked about, nothing about the straightening device that was found, nothing about using the password non-11 that was part of how they tied Mr. Noel to those videos. And then, of course, there was some non-corroborating evidence too. Remember, the neighbor testified. She says she never saw them alone. She never saw the defendant alone, and of course, that she wouldn't have an opportunity to see every time.
I don't know if
Okay.
you, well, go ahead.
So I know you're saying you wanted to ask specifically about this oldest brother, but did the defendant ever just ask the defendant and the victim in approximately the 8 years that he was accused of abusing her, that did she know she could report somebody for this?
I mean, that wasn't part of the cross, right? And I think,
But it could have been. It could have been, though, right?
Well, but why would you ask that? You don't know what the answer is. That would be, there's a reason that wasn't asked on cross, which
sorry.
is,
No,
I'm sorry, I got.
no, it doesn't matter. Go ahead, Judge.
Well, she's alleging this happened up until she's 18, and so either answer could have been helpful for the defendant. If she said she didn't know, that might have seemed very incredible, and if she said she knew, that would be helpful, right?
Right.
But that you had the chance to ask that, and you didn't.
Well,
Or
defense
not, I don't know if it
counsel-
was
yeah.
you, but yes, but defense
I mean,
counsel.
You could say that there wasn't a specific bar on him asking questions about her ability and knowledge to report, but he specifically asked about doing it in this way, right?
Right,
And
and
this
so
would have been
so first of all, again, the record is, does the record ever establish how much older the older brother was than the victim?
I am not sure if that is in there, and I can look to see. I know that.
It seems he was a minor because, I mean, it seems like the inference is he's a minor because he was sent to live with his father.
Right, and I know that he was, I know that the brother who testified, a different brother, right? That
Right,
brother was
oldest in the middle.
A year and a half or
Yep.
2 years older, and this brother
Right.
was somewhat older than that, but I don't know if I have that in the record. Commonwealth might have that.
So is there any evidence that the victim was the reporter of the oldest brother touching her? Like a
So-
parent could have walked in on them, some other adult could have walked in on them?
Right.
We
Also
have no
not
idea.
clear. And that issue came up in the discussion that the attorneys had with the trial judge when defense attorney was trying to get this in. And the point really was like, well, it doesn't really matter if she went out and said, hey, this is happening to me or not. The point was, there would have been an investigation. She would have had a conversation with a DCF worker or some other adult of authority about what good touching was, what bad touching was, and she would have been given some information about how and when to report things that were improper. That's not
That's a big
speculative,
assumption,
right?
isn't it? I mean, if an adult walked in and saw him touching her, then do you need that conversation?
Well, presumably, if DCF is doing an investigation, and I don't think this is speculative, I think this is pretty straightforward common sense. Some DCF worker is going to have a conversation with the child, whether it's with the mother present or whether it's with somebody else, about the conduct, right? So she would have been given some information about what was appropriate conduct, what wasn't. And to the extent that, the defendant had few avenues, right?
Right.
To exploit.
Okay, but the allegation against him was that he touched her over her underwear, right?
I believe, right, and that's from the defense counsel. I don't think that is anywhere in the written documents in the record, right?
Okay,
So one
but
of
you
the-
talk about transference, and there's no allegation that this brother videotaped her, correct?
No.
Okay. So assuming that she knew she could have reported someone for sexually abusing her during this period of age 10 to 18, can you explain how that bears on her credibility?
Because it would have gone to the credit, the Commonwealth often calls experts, right, to sort of
On
stop
delayed disclosure.
this inference, right? That's why they call Stephanie
Right, but
Block,
they didn't
right?
call her here.
They didn't in this instance, but the point is that this would have been a way for the defense to say, is it really credible that all of these horrible things were happening, and she didn't go and report it to
But
anybody?
we have
She
video of
knew,
horrible
right?
things happening, which she says she has beauty marks that would, and she identified herself, her brother identified the mask in the green bedroom, and I don't know, because we don't have any images, we don't know, like, is this like just a pretty spring green, or is this like a neon green?
Okay, so, yeah.
Sure, there are hundreds of greens.
Right. And I mean, if you look at the defendant's closing argument in the first few pages, he does a very nice job of setting out why it is that all of those sort of corroborating facts were assailable, right? But what he wasn't able to do was say with real force, of course this couldn't have been true because we knew that she knew how to report this. She had done it before. She had the capacity and the ability to do it. And so,
Can I
But
interject there?
that's still true for the teacher, right? Because she's 16, and the allegations are that this continued until she was 18, right? So they knew at least during some period of time that she knew that somebody could be told, an adult could be told.
that was much later. And even the Commonwealth's own theory as it comes out is that it was early on when she didn't report because she felt like she was on Noel's team. And then by the time she got to high school, it was that she was so sort of involved in his life and felt like she just was trapped by the whole thing and couldn't report it even though she had the capacity to know how. So it was really that early portion that the defendant was trying to demonstrate to the jury.
Right, but
would be
for
a
every
reason-
single rape, she was under, every single rape count, she was under 16. So it doesn't matter, for example, if she consented, correct? It's still rape.
Right. It's not about consent. It's about ability to report, right? And about
Right, but
the
if she
jury-
had the ability to report, I don't understand how that connects to whether he raped her, whether there was sexual intercourse before 16.
It's the defendant saying to the jury, this is not a credible account, not a credible narrative, because it's just unbelievable that all of this could have been going on and somebody who had reported this type of thing before wouldn't have reported it again. And that was one of the few avenues. that
Okay,
we had.
your time has expired. I have one question. There may be more.
Yeah.
You haven't talked at all about the character evidence. Am I correct that a single objection, maybe it's two, but about the same passage or types of passage, were made on character evidence grounds below, and both of those objections were sustained? Is that correct?
So, the character evidence with respect to the one about providing the man in Africa with money.
The objection
there
was
an objection on
relevance.
It was overruled and there wasn't a follow-up objection.
Well, it is, yes, it is relevant, but it may just be character evidence.
Well, I disagree with that just because, and I noticed.
Well, if she testified, there's some, I mean, it's got something to do with her credibility, doesn't it?
Well, I think in that case, it's just piling on. Why does the jury need
Okay,
to
but you
know-
didn't say character, no one said character evidence.
He didn't make an objection on character
The
evidence.
character evidence objections were only to a description of the defendant's sexual attraction and to how a group that he's in is not accepted.
Right. No, the Commonwealth accurately
So
described that.
basically, and those were sustained. I know there was no motion to strike, but they were sustained. So there's nothing to really appeal from on those objections except, preserved to. So it's all unpreserved
Right. So it's
claim of error. So it's substantial risk of a miscarriage of justice from the evidence that you outline in the brief.
And,
Okay.
and just the final word here is that where the defendant, there was a lot of that kind of bad act evidence, and he was prevented from exploiting one of the few avenues of cross-examination that he had, and then on top of that, any progress that he made was undermined by this excessive bad act evidence.
You can, yeah.
I have, going back to the report at the age of 4 and 5, to me, the single biggest problem for you is that it's age 4 and 5. Trying to apply the correct rubric, analytical rubric on appeal, the judge has to decide whether this evidence was admissible. The first step, the main step, is relevance, and the judge has discretion, and the judge, in one of the reasons the judge cited, I believe, you correct me if I get this wrong, is that she was 4 or 5. How can we reliably understand that there was a conversation? Okay, let's accept that a DCF worker had a conversation about good and bad touches. Okay, I don't remember, I don't know when my first memory was, but it was somewhere around 5 or 6. It was not, it's possible, it's not at all clear that I would have had a coherent memory of age 4 or 5. This seems like clearly reasonable for a judge to say, that's just not something that she could have remembered, period.
Well, I'm not sure about where people's earliest memories are. Certainly kindergarten at age 5 seems...
Right, and given that it's abstract, isn't this exactly where a judge is supposed to apply his or her discretion to figure out what's relevant? And isn't this a borderline call that means that we say that's not an abuse of discretion? Is that the right standard? Abuse of discretion, not relevant, end of story.
Well, the finding on relevance is going to be based on an abuse of discretion, but if it's relevant, right, if you find it's relevant, and then it is error to exclude it, because,
Right.
because it was for the purposes of showing false testimony that she gave in other areas. And I would say this is relevant just because DCF would have been involved. They were involved for an extended period, right? Of course she would have understood at that point how these allegations are disclosed and made, even if it was at an early age.
Thank you.
Thank you.
All right, thank you very much. He's had an extra 5 minutes and 14 seconds, so if you need it and you run over, you will be given the same.
Thank you.
Yes.
Good morning, Your Honor. Sarah Lewis on behalf of the Commonwealth. With me today is the trial prosecutor in the case, Assistant District Attorney Allison Portney. This is a case where 2 judges, the motion judge at the Rule 17 stage and the trial judge, exercised their proper discretion and rulings that were grounded in Massachusetts law, protecting the defendant's constitutional rights and the victim's rights to privacy. These rulings were fully consistent with a fair trial. The jury rendered a reliable verdict in a case with overwhelming corroborating evidence of sexual abuse. I'd like to just first begin with the Rule 17, unless you have a question, Justice Wood.
I'm just trying to frame this correctly in my own mind. Overwhelming evidence, I get it. I think I hear the defense to be saying that, first of all, their defense very simply and directly is, he didn't do it. This is not the defendant in these videos, and that means the victim here is lying. That's their defense, okay? And in the videos, which we don't have, it appears that the victim is wearing a mask the entire time, and the rapist is not pictured. And so it's not crazy to be saying that there's a real ID question here. And which is why where we started, to what extent is it, in my own mind, I'm not clear about the answer to this. To what extent is this a real ID case? And is it possible that she's lying? And so that's where I'm beginning. And I think that one way we can cut through a lot of this is if we have the videos and documentary evidence that we talked about. It's an open question in my mind. I'm trying to be candid here.
Understood.
That this is not an overwhelming case to me yet because a piece of this is missing. I just want to start there. So when you go ahead and argue.
I understand. And
But is your position he should have provided and he didn't, so now he's out of luck on prejudice?
I think, yes, I think the record as it stands that was presented, overwhelming evidence to the jury, was more than sufficient to show this court on the reading of the record that the evidence, again, was not only a story, a credible testimony by the victim, but corroborated by evidence of the videos.
Right,
Those
so
videos,
our
though-
problem, I mean, obviously the jury agreed and they convicted him. But the question is, he didn't provide us with the videos and the stills that show her beauty marks or the defendant's patchy legs and the videos so that we can see what the jury could have concluded. So the question is that too late and you're saying this is our record and so he loses because we can't determine, we just have to take it as a given that the jury agreed that it was her?
I don't think necessarily. I think this court, certainly after argument, I can move to transmit the videos and the photographic evidence to this court, and I think it helps the Commonwealth's case.
To be clear,
Right, but my understanding is you're not going to copy it because that could be a crime.
Understood.
Okay.
Understood. And so we'd have to figure out the proper mechanism to do so. But I think that, yes, it's the defendant's burden, and so I agree with that part, and the Commonwealth's argument is that even if this is error, of which, any error in this record, of which we absolutely do not concede, any error would be harmless beyond a reasonable doubt because of the overwhelming evidence. And for you, this court, to not only see that very clearly in an extremely well-tried case, but to see it with your own eyes would be supportive of the Commonwealth's position.
Right. And just to clarify, there is no claim by the defense of sufficiency. They're not challenging sufficiency. I'm not arguing with you. I know you get it. I can hear you get it. But just to be clear why we're doing this, the defense has raised this issue, and both sides have clearly, and very well briefed by both sides, have said has made reference to the record evidence. So the photographs in the medical records and specific aspects of the videos. There's nothing inappropriate, as far as I can tell, about us saying this evidence that you've made reference to that supports the defense argument should be presented to us so that we can evaluate it ourselves. I'm not arguing with you. I know you get it.
Or,
And I agree-
or
I-
should have been presented to us.
But can now be presented if we say it's relevant.
I
and
think
we need
it can now. I would.
Right.
I would say that, as your honors know, you can't act as a second jury, but but in order to evaluate the strength of the evidence, I would say it's clear on the record. But I don't think there's also a problem with confirming.
I mean, I have to say, this isn't, I mean, obviously we can look at all the evidence in the case. In lots of cases, it makes a big difference. Where they haven't challenged, or the defendant hasn't challenged sufficiency, I mean, I guess it might go to the overwhelmingness. There's clearly sufficient evidence for the jury to have found that, as they apparently did, that indeed this was the defendant and the victim in all of these videos and still photos.
But for
But for it to be overwhelming, maybe it had to be not a close call. I guess that's what Justice Wood is saying.
on the defense's actual arguments, it depends on the strength of the evidence. Assuming for the sake of argument that the DCF records from when she was 4 or 5 were erroneously excluded, that's not the end of the story. The question then is, and again, you get this. I'm not preaching. I'm not trying to yell at you.
No, you're trying to conceptualize.
I'm trying to conceptualize it. This information is relevant to determine harmlessness of the error under the appropriate prejudice standard. I don't want to belabor the point. Anyway, sorry.
And I think I don't want to say I'm struggling. I wrote in my notes too. There's not a sufficiency claim here, right?
Right.
And this court reviews the record, and the record includes the evidence presented to the jury.
Well, there's the record and there's the record on appeal.
Right.
And the record on appeal is supposed to be prepared by the appellant, in consultation with the appellee to get anything that they want in it, and then it's presented to us. We don't have to look beyond that. That's what the defendant says we need, and so we look at it. Of course, there have been cases where we have gone through the entire record and the critical document or whatever it is just isn't in there, and we do get it from the clerk's office because as a formal matter, all of the evidence is in the record and we can consult it. I want to ask you a question about what seems to me maybe the more substantial claim. Because if the evidence is as you describe it, it does seem like those first two errors would be harmless beyond a reasonable doubt. And it might be that any error is harmless beyond a reasonable doubt. But if half the case was overwhelming evidence and the other half was character evidence that was impermissibly put in, I could see someone saying, well, look, how can you say that's harmless error? Surely this played some role in the deliberations. I'm not saying it would have come out the other way because, you know, there's a lot of evidence, but surely the jury can't be told to consider, you know, all of this stuff. So my question is, why isn't there a ton of character evidence in here? And let's start with the unobjected to on this ground. What does wiring money while dressed as a spy to someone in Africa have to do with this case at all?
And I understand your question. I'm going to answer it directly, but I do want to say that in this lead up to this, we have been assuming error. And the Commonwealth's position is that the judge did not abuse her discretion at the motion stage, at the trial stage, nor did the trial judge, nor was there any impermissible prior bad act or character evidence admitted. Now, in terms of the testimony that the defendant sent money to a child pornography producer in Africa, the objection was, again, on the ground of just relevance.
It's unobjected to. I'm fully aware that we're talking about substantial risk, but why isn't it, what does it have to do with the case?
It absolutely has to do with the fact that the defendant here was a producer of child pornography. That's what the evidence suggests.
Was he charged with producing child pornography?
No, but he is charged with dissemination. And the fact that he is sending money to this person in Africa is relevant to that two charges of dissemination. And not only...
How is that relevant to dissemination? That's him sending money, not pornography.
I think it counters any claim of accident or mistake.
He didn't make a claim of, did he make a claim of accident or mistake? I thought his claim was that I didn't do any of this.
Exactly, but I think the Commonwealth is allowed to, is permitted to introduce evidence to rebut any suggestion of accident.
But there was no yes, I agree to rebut. But if there was no suggestion of accident or mistake, I don't think you can just pile character evidence on and say, like, if someone had said it was an accident, this would prove it isn't. It's 20 of the same act or whatever.
But I think it showed that he is not just disseminating these videos on Dreamboard. And that's what, I mean, these videos were found on 3 different people's
Yes, I agree with that. He was charged with and convicted of dissemination.
And well, okay, so I would say it's relevant to dissemination, but I also think it is relevant to credibility. She was able to testify specifically to the detailed way in which he disguised himself and sent this money to this person in Africa. And I think it shored up her ability to remember, her credibility.
What was the money for?
I'm sorry?
What was the money for, do you know?
For making, my understanding of the testimony is he was sending money to somebody in Africa who was also making videos.
Why?
The testimony did not continue.
So we don't even know what this was about.
I think that the relevance of this was not only that he was a producer of child pornography and it went to his absence of mistake.
Although it went to his character.
Yeah, but
right, it really goes to his character.
And pales in comparison to the overwhelming evidence of what he did to this victim over a 10-year span. And I think we need to bring it back to that evidence.
But then now we're talking about harmlessness, or not even harmlessness, we're talking about because it's substantial risk, whether it affected the deliberations of the jury or not.
And I think it absolutely did not in this case. I think the characterization that there's overwhelming prior bad act or character evidence in this case is inaccurate. There was that testimony about him sending money to Africa, and again, if not relevant to dissemination, surely credibility in terms of her memory, her conversations she had
Or maybe
with
she
this
shouldn't have
defendant.
even been able to talk about it. Maybe her own description of him doing that was just character evidence.
And I understand that, but her ability to recall specific details about the way in which he sent this money was consistent with her recollection about
No, it does all make it seem like a true story, of course. But we don't let in past bad acts that make it seem like a true story. Like,
I would disagree with making it seem like a true story. I think that it shows that she is, as she testified to, on a team with this defendant. She is working with him in this creation of these videos that the defendant then uploads on this website, which she has an understanding of only because of what she knows from this defendant.
Wait. The him sending money to the African guy wearing a disguise, all of that information comes from her, right? From her testimony.
Yes.
There's no corroboration. So her saying that if the defense is she's lying, then that doesn't actually. Your answer was. That shows her credibility because it enhances her, it's relevant to and enhances her credibility because she has a detailed memory. But if she's lying, that doesn't answer the question whether she's lying. But I have a different question. My question is about the testimony from Futrell about the activity of other Dream Board members, and most troubling to me is the fact that, and I don't want to use this person's name, I'm sure but T, not the alleged victim here, but is a victim of a horrible rape, and now they're trying to figure out her identity. The Dream Board members are trying to figure out her identity. That sounds horrible and terrifying, and if that happened, it's terrible. But as far as I can tell from Futrell's testimony, that didn't have anything to do with the defendant. There's no allegation that the defendant was involved in that conversation.
No, but I would disagree. It's highly relevant.
Okay.
The victim testified that during her training period, when she was in middle school, she was shown videos by the defendant of other children.
Yep.
And one of those series of which she was shown, she named it as that child that Futrell ended up testifying about. So she has this memory from conversations with the defendant. Does that answer the question?
Yes, that does. Thank you.
All right,
Thank
so,
you.
So the defendant says that, yes, she gave all these details, but actually a whole bunch of them were not in the first SANE interview. I think the implication is that maybe they were fed to her by the prosecution. So what do you say to that?
I would agree that some of the details were not in her initial SANE. I don't want to characterize those details as insignificant because I think all the testimony here was significant. But there were many details she gave in her SANE interview that she testified to, in the SANE before she was ever, or she offered in the SANE, before she was ever shown the videos or knew about the videos having existed. So again, not insignificant, but there were many other details that she gave that were corroborated by the videos that were eventually obtained. Also, the defendant crossed the victim on all of the details very clearly that she did or did not disclose in the SANE before receiving the videos. So for example, she said that during her SANE interview, again at trial, that she and the defendant would insert sex toys into her vagina. That is corroborated by the video. I can go through that she wore the Mardi Gras mask. That was in her. The SANE's not part of the record, but these things.
That's the next thing. Okay.
Well,
right.
and that's on I would say that is the SANE interview was not part of the record at trial, and I would say that is on the defendant to have not offered that. I don't mean as a trial exhibit, but just as part of the record. But I think what this court can glean is because the defendant very clearly and in a detailed way cross-examined the victim on what she did not say in her saying prior to seeing the videos, it can be deduced what she did say before seeing the videos.
Okay, so the defendant argues that the standard of review for not allowing cross-examination on the topic of abuse by the oldest brother, they say the standard of review is harmless error. Do you agree with that?
So it's a constitutional challenge. I think it's harmless error, and the Commonwealth does analyze it as such in its brief, where it's a complete foreclosure on cross-examination. But we don't have that here. We have the judge who did allow the defendant to cross-examine the victim on a prior allegation involving the teacher when she was in high school. What the judge foreclosed only was this prior allegation when she was 4 or 5 years old. So this was not a complete foreclosure on cross-examination, as was the case in Jocks. This was a reasonable limitation on the cross-examination where the prior allegation when she was 4 or 5 years old, had no reliable bearing on her credibility as the trial judge found.
Analytically, it's actually an interesting question to me. I'm wondering if you can cite to, I know about Jocks, but another case that's analytically follows this pattern of conceptually there's the topic, and there are two examples of the topic, and defense is allowed to get into A, but not allowed to get into B.
Yep.
And does that constitute complete foreclosure or not? It seems like there's two reasonable arguments there. Is there a case that's decided that?
I would cite the Commonwealth versus Seeley, 467 Mass 617. That's a U visa immigration case before the SJC, and in that case, the defendant sought to cross-examine the victim on a prior disclosure, on a previous allegation of sexual assault and resulting immigration benefits she received. That was foreclosed, but what wasn't foreclosed was, the court said the judge's ruling did not exclude all evidence on the victim's motive to lie. He was permitted inquiry into how the victim learned of her eligibility for a U visa and how that might have informed her allegations. So I think that would be the closest case. I actually think that's an incredibly helpful case here when you look at how not only the standard of review, but as Your Honor said, not a complete foreclosure on cross-examination. Also, it gets into Rule 17 and records that were denied in that case where the defendant did not make a sufficient proffer, which would be the Commonwealth's argument here as well. So I would point the court's attention to that case.
So turning back to the DCF records, the second argument he raises, he argues that he only needed to show that they were relevant, that there was a likelihood of admissibility. Do you agree with his standard? And he also says the Commonwealth didn't contest the relevance.
I do not, we're in the constitutional realm, not the Rule 17, correct, Your Honor?
I was moving to the Rule 17.
Oh, the Rule 17, I'm sorry, okay, I wanted to be clear on that. I disagree that it's only relevance. Under Dwyer and Lampron, the question is a showing of specificity and particularity, relevance, and a plausible theory of admissibility. Relevance is judged in terms of whether the proffer shows that the records might be relevant to prove or disprove an issue in the case. So I don't think it's just relevance. The showing here was wholly insufficient to meet the Dwyer and Lampron standard. The proffer was based on speculation that the records might contain material that bore on the victim's credibility, and that has been repeated, a showing such as that has been repeatedly foreclosed by this court and the SJC as resulting in piercing statutory privilege records here of a child rape victim.
Okay, and then he says that the Commonwealth's narrative was that about why she didn't report was because she didn't understand it was wrong, or maybe she didn't know that she could report. What do you say to that?
So that was I would say, a reformulated claim at trial. At the Rule 17 stage, the showing, the proffer, was just that there was this prior incident that could have a bit, truthful or not, could have a bearing on her credibility. First of all, if it's truthful, it'd be inadmissible under rape shield, and if it's a false allegation, the defendant made no showing or sufficient showing of that. But in terms of, and now I've lost my train of thought, can you repeat your question? In terms of the relevance of it, and then reformulated that at trial in terms of it shows that she knew how to disclose, and therefore it's relevant. I don't think that there was a sufficient showing of that she knew or didn't, that she disclosed this. It was an allegation that her brother touched her over or under her underwear. She's removed from the home and then she's returned. That's what the record showed. And even if we know that she made this allegation and that's why DCF was involved, and I think that's speculative about how that transpired. But even if that, I still don't think it's reliable on the issue of credibility, where this allegation was made when she was 4 or 5 years old, and he was permitted cross-examination on an issue that went exactly to his purpose for which he sought to admit it, this idea that she knew how to disclose but didn't disclose this abuse. He was allowed to cross-examine on the allegation against the teacher in high school, which was less remote and less speculative than what the trial judge, within her discretion, excluded.
All right, I think this is my last question, but everybody keeps saying 4 or 5, but I think she's in the Boston Public Schools, so does it make a difference if she was 5 or 6? You don't get to kindergarten, I mean, maybe pre-kindergarten but generally kindergarten.
In terms of the prior allegation?
Yeah, does it make it, does it make a difference if she's 4 or 5 or 5 or 6?
Does it make I think both are remote in time, particularly where the charged abuse was starting when she was in 5th grade, and the allegation against the teacher was less remote, was consistent with that time. In terms of what we have on this record, again, the scene was not introduced where there was some information, but on this record, it was that she made this allegation when she was 4 or 5 years old against the brother. That is remote. The allegation was speculative, and it wasn't admissible, and his constitutional rights were scrupulously honored. The victim's privacy rights were honored, and this was a fair and just verdict.
I did qualify that I thought it was my last question. That's why you never say that. He says if DCF was involved, they would have talked to her for sure, even if the issue was discovered because somebody walked in on the kids. And they would have explained good touching and bad touching. What do you say to that?
I'd say that it's not on the record and it's speculative.
Thank you very much. Thank you both for giving us the extra time. Obviously, it's such a concerning case, and
Thank you,
we appreciate it. So thank you both very much. The case is submitted. We will now take our mid-morning break, and we'll return in 10 to 15 minutes and hear the remaining 2 cases on our list.
Close the session. Please be seated.
Hello again. Weird, still morning. Good morning. We will hear next number 25-637, Deutsche Bank National Trust Company as trustee versus Futrell and another. And we will hear first from Attorney Linehan.
Good morning, members of the panel. May it please the court. My name is Brian Linehan, and I represent Deutsche Bank.
Could you move the microphone up more toward you?
My apologies, Your Honor. May it please the court. My name is Brian Linehan, and I represent Deutsche Bank National Trust Company, which is the appellant in this appeal and the plaintiff in the housing court action below. Deutsche Bank appeals from an order denying its motion for reconsideration of the housing court's prior order denying Deutsche Bank's motion for summary judgment and granting allowing the defendant's cross motion for summary judgment. Now, before I dive
Am I correct that you were not the attorney for Deutsche Bank during the appeal period?
Correct, Your Honor.
Okay.
Yes. The different Attorney Coletti represented Deutsche Bank during the summary judgment proceedings. We came in for the motion for reconsideration. Now, before I dive into the substance, it's just important to touch upon the significant, the potential devastating prejudice that this judgment could have against Deutsche Bank, because, as I mentioned, this arises out of the court's order on summary judgment. And in that summary judgment order, the housing court makes a particular and demonstrable error in that it finds that the originating lender, Home 123 Corporation, sold this loan after it filed for bankruptcy in April in 2007. When in fact, Home 123 sold the loan.
I think you should actually not start with prejudice. We'll get to that if there's a reason for us to look at it. Let's
Certainly.
talk about, because that might have been an excellent argument on appeal, but you didn't bring one.
Certainly, Your Honor. It's just a matter of that this is not a defect that can be cured. They can't get an assignment of mortgage from the bankruptcy trustee if the bankruptcy trustee never held an interest in the mortgage, which is the case here. So if this judgment stands, it's possible the defendants are going to get a free pass.
I'm going to leave it to you, if the judgment stands, to figure out what to do next.
And so, diving into the substance of the arguments, I'd just like to touch briefly upon the legal standards applicable to a motion for reconsideration, because that was raised in the briefs. So in seeking reconsideration of an order on summary judgment, the movement must show a particular and demonstrable error in
I couldn't disagree more. Where do you get that from?
That's from the Shoe versus Shoe decision.
This has been held to be an unreasonably late motion for reconsideration. Doesn't it have to be treated? I thought you conceded this ultimately, that it has to be treated as a 60B motion.
Correct, Your Honor.
All right, so it's not demonstrable error, whatever that is. It's something under either 60B 1, 2, 3, 4, 5, or 6.
Correct, Your Honor, yes. So, and that's what we rely on. We rely on Rule 60B in the motion for reconsideration, but in applying those standards.
Which subsection?
So in the legal standard, we don't actually discuss which subsection, but the discussion throughout
You can tell
the motion
us.
is mistake or error of law. And
Error of law is not one of the reasons. Mistake is.
Correct. But in assessing, in the Shoe versus Shoe decision and the Blake decision, they don't necessarily talk about what standard they're reviewing under, what rule the motion was filed under. They just speak generally that seeking reconsideration of summary judgment, the issue is particular and demonstrable error. That's where we get that from. And that can be applied.
What's your best case on that, and what section of 60B? Because arguably, if you don't tell us, we go through all 6 sections and we have other things to do. So if you know for sure you're under a particular section, could you just spare us?
Yes. So this would be under Rule 60B1 for mistake. Yes.
Okay.
And it is mistake of fact in the fact that the judge found that the loan was sold after the bankruptcy when in fact it was sold before the bankruptcy.
Right, and so on that point, I think the gist of your argument is we didn't have notice that this was a problem. But before you didn't appeal, the other side clearly makes the argument that this is invalid. Their core argument is this is invalid because, I'm going to get this wrong, the mortgage was assigned post-bankruptcy, and that makes it, when it's without the approval of the bankruptcy trustee, then it's invalid. Did I state that right?
That's correct, Your Honor, as far as the defendant's argument goes. But
Okay, and your defense to that, if it's not really a defense because you're the plaintiff, is no, that doesn't apply under Riley, unpublished decision, if we had the note before the bankruptcy. That's the defense to that, right?
Correct, Your Honor.
And you had notice of that problem, or that claim, rather.
You even cited Riley.
Correct, Your Honor, yes.
And so why, so now, Judge grants, you don't make any mention of that in summary judgment proceedings. Judge finds for other side defendants, and you guys don't appeal that. Isn't that the end of it?
Well, Your Honor, there are several issues, and I want to back up because it involves the standards, the burdens of proof on summary judgment here. Because if you look at, the procedural history, Deutsche Bank filed its motion for summary judgment in May of 2024. And at that time, the only thing in the court record regarding the defenses that were going to be raised are in the affirmative defenses in the answer. Those affirmative defenses don't mention the bankruptcy at all. The closest they get is they allege that the assignment of mortgage is void for lack of
But
signing.
after Ross was cited to you, you were invited to do additional briefing, and you did so on the issue, failing to mention, and in our case, before the bankruptcy, right, I mean, you cited Riley for the mortgage as an asset of the debtor.
But that's the problem, Your Honor, is
Or
the
not an
mortgage
asset at all.
is not the asset. The note is the asset.
Well,
And that's where the
according
court-
to Riley, I think it's wrong, actually. But according to Riley, it is.
The unpublished, right?
The unpublished Riley, right? I mean, we're not bound by it anyway, but this is putting carts before horses galore. These are terrific arguments, including that this is the first we've heard of it, for appeal. Maybe even for a motion for reconsideration within the appeal period. Sometimes we might say 30 days, but, whatever. Banks wanted a shorter appeal period for these cases, and so there it is, but everyone has to play by that. All right, so.
And so on summary judgment, right, the defendants...
I want to stick with whether we get to summary judgment.
Certainly.
All right, here's my regular hypothetical. And you can tell me why this isn't that case. Oh my gosh, I've lost this case. The judge didn't notice and wrote that I'm not a farmer. And also, he misapplied the standard for the Farmers Whatever Act, and I don't owe this tax. I shall appeal. Nah, I didn't. I don't know. I was looking at TV, and 30 days passed, and I didn't do it. I know. I'll ask him to reopen the judgment. Judge, could you reopen the judgment? You've made these two mistakes. And the judge writes, like I said when I issued this 47 days ago, you're not a farmer, and this is how the law works. I continue to agree with myself, which is what most judges would say if they reach the merits. And now you can appeal that? So why isn't this just an end run around failing to appeal unless you've got something bigger, fancier, differenter than that, assuming mistake includes a mistake by a judge?
The appeal is limited to the order denying the motion for reconsideration.
This appeal, I agree, and what I'm saying is, exactly. And since all you raise is errors that could have been raised on appeal, it was no abuse of discretion to deny it.
But it's not that the issues could have been raised on the appeal, as Judge Wood pointed to, because in the affirmative defenses, this issue was not raised.
Yes, you could have raised that on appeal. Frequently, when something happens in a court that's wrong, and you had no notice of it, the first opportunity you have to raise it is on appeal.
Correct, Your Honor. But in this case, because there were no facts in the record as to the loan sale, the appeal might not have reached that issue. And so we wanted the opportunity.
Wait, I'm sorry. I don't know what the appeal might not have reached that issue?
Well,
they might have found it waived.
Right, but without that fact in the record, and it's important to back up, just during the summary judgment arguments, the judge, he conflates the terms loan and mortgage and asset.
Then maybe you should, if Riley's right, maybe you should have filed a motion in order to clarify all this, for reconsideration before the judge during the time when you could have filed a motion for reconsideration.
Certainly, Your Honor.
But you didn't, and so we were left with a 60B motion. And the idea that every judge has to reopen their case because there's some fact misstated in it that the losing side didn't raise either during the reasonable time for motion for reconsideration or during the appeal period And then if the judge doesn't fix it, they get to appeal on the issue in the underlying case. That's chaos for our legal system.
Certainly, Your Honor. And here, it's important to note, we're not trying to appeal the underlying judgment.
Yes,
We're
you
not
are.
asking for
You
judgment.
absolutely are.
Well, not necessarily, because it's important because it's a motion.
Do you want the summary judgment to stand against you?
No.
Okay, so
But-
you're appealing the underlying judgment.
I understand that, Your Honor. I understand why you would be concerned and why it's.
Can I zero in on something you said about something I said?
Certainly,
You said that the affirmative defenses don't mention the mortgage assignment being invalid. But so what? Before the judge made his their summary judgment decision, did the defendants make this argument?
Before you issued the summary judgment decision, yes. It was, so, to clarify, I just want to back up for a minute. The affirmative defenses do allege the assignment is defective based on a lack of signing authority. I wanted to clarify
Okay,
that.
all right.
But signing authority does not render assignment void. And here, the only argument that was raised in the statements of fact and the affidavits and the documents that were submitted in summary judgment was that this mortgage was assigned after the bankruptcy. Now, there is nothing in the law that says
Okay,
that.
but stop. So the defense was it was invalid because it was assigned, this is what they alleged, that it was invalid, the assignment was invalid because it was assigned after they had entered bankruptcy. That's their defense. And so that's the notice, from my point of view, that you know, okay, we have an answer to that. And the answer is the note was blah, blah, blah beforehand. And so you have notice. That's the fatal flaw in your argument to me, that before the judge, and the judge, as Justice Rubin said, says, okay, this is confusing, I'm going to give everybody, and actually the Deutsche Bank lawyer says in that hearing, I need to present more information. Can I do that? Sure. Let's have a continuance to give you a chance to present more information. I think he was going to go look for the mortgage, which he couldn't find. But my point is, they had Deutsche Bank had ample opportunity to address the argument that the defendants were making.
But there is the problem is the distinction between the note and the mortgage. Because as I mentioned, all of the statements of fact, the discussion and oral argument, they talk about the mortgage. But in order to challenge the assignment of mortgage, the defendants have to allege that it's void under the Culhane decision. Being recorded after the bankruptcy, while the trustee, if this was part of the bankruptcy estate, the trustee may have the right to object. That assignment is entitled to presumptive validity under Chapter 183.
I'm not understanding what you're saying. I'm sure it's my own ignorance of this area of the law. But I thought that the defendants were absolutely arguing that the assignment of the mortgage was invalid, void, because you can't take the house because you don't have the mortgage, because it was the assignment of the mortgage was invalid, because it was assigned after the Home 123 had gone into bankruptcy. That's the effective argument.
But the problem is that as a matter of law, Your Honor, being recorded or executed after the bankruptcy does not render it void.
You absolutely should have said that in what you filed supplementarily under the thing.
This was argued that the defendants did not have standing to challenge because it's not void based on the facts that they presented.
I understand, but you didn't say, and if it could be valid, it wouldn't be in this case because the note was sold prior to bankruptcy.
But that's not Deutsche Bank's burden on summary judgment. The defendants filed the cross motion for
Yes,
summary judgment.
but you have to respond to what they're saying, and if the judge doesn't think that that you're right, the judge can say so.
Certainly, but at that point, there was nothing suggesting what way the judge was going to go. And because the defendants had not alleged facts sufficient to show
Let me
that
ask
the
you
assignment was
this.
void.
And I'm not at all sure we're going to get, or I'm at least going to get to this. Why isn't the untransferred mortgage an asset?
Because in Massachusetts, unlike other title theory states, the mortgage does not follow the note.
I agree with that. So why isn't it a separate asset?
Because when the note and mortgage are separated, the note is the debt instrument. That's
Yeah,
the
I
right to
agree with
enforce
that.
it. When they're separated, the holder of record of the mortgage holds it in trust, and their only interest is in mere technical.
They hold it
use.
because you're the equitable owner of it.
The equitable trustee of the mortgage, but the note holder is the owner of the mortgage, and they have the right to demand an
I don't
assignment.
know that. What do you mean they're the owner?
So
They don't have possession of it. It hasn't been transferred yet. The record owner of it is certainly still whoever holds it.
Certainly. But under Eaton and Ibanez, when that happens, the transferee, the note holder in that situation, has a right to demand an assignment of mortgage, and that assignment must be provided. The note holder.
What if they've entered a contract that sells only the note?
I'm sorry, what was that?
What if they enter a contract that for less money sells them only the note?
Yeah, Your Honor. In Massachusetts, I mean, they could, but they wouldn't get the mortgage.
They could, and the reason is they're two separate things.
But
I mean, it might be stupid to do that, or it might depend what the condition is for getting the mortgage there. You can have the note now for $500,000, and if you come up with another $500,000, we'll also throw in the mortgage.
But in Massachusetts, and this is discussed in the Eaton decision, without the note, the mortgage is a nullity. It has no effect. There is no rights under the mortgage once the note is null.
And without the mortgage, the note is a nullity.
Not necessarily, Your Honor, because without the mortgage, the bank could still file an action on the note to recover the debt. That is the distinction.
Yes, but they don't have the money for the debt. That's why you bought the note.
But that doesn't take away the right to sue. They could get an attachment. If for some reason the mortgage is unenforceable, they could get an attachment, and that would preserve the right if the property were sold. There are other remedies for collecting that debt. But the point is that without the note, even if I'm the holder of record, I'm holding that in trust. And if I file bankruptcy personally to reorganize my debts or to seek a discharge of my debts, any property that I hold in trust on behalf of somebody else is not part of the bankruptcy estate because I don't have any ownership rights in that property. I'm holding that for somebody else. And so here, Home 123, when they sold the loan, and under Riley, they recognized that the loan includes both the mortgage and the note, and the sale of the loan is different from the assignment of the mortgage.
I agree.
That's the distinction. So when they sold the loan, and Home 123 continued to hold that mortgage, they didn't have any rights that would be transferred into the bankruptcy estate because Home 123 can't enforce that mortgage without the note unless
That sounds like the opposite of Eaton. Eaton says they're two separate things. Right. You're saying once you've sold the note, you've sold the mortgage. That sounds like they're the same thing.
Well, it's not that. So the sale of the loan, right, includes the note and the mortgage. And this is described in the pooling and servicing agreement. There's a definition of the term mortgage loan, and it says it's the loans listed on the loan schedule, right? And the collateral that transferred, it says including the mortgage notes, but it's all the loan collateral. But the note and the mortgage together are what function as the loan, right? And then when those are separated, it's just like, you know, if somebody else has the rights under any other contract conditioned upon security, if another party is holding that security and they just have not transferred it to the party that has the rights in that security, that doesn't mean that they have ownership interest in that security. It just means that it has not been properly transferred yet. And you know,
well,
as
all
I
right.
stated,
If we get to the question, I think we'll have to look at it more. Your time has expired, but.
So you say this is a devastating precedent, and I don't understand why it's not cabined to its very unusual facts.
I'm sorry, could you repeat
You
that?
say this case is a devastating precedent, and I'm not understanding why it's not cabined to its very specific facts that you didn't put in evidence you should have put in.
I'm sorry, Your Honor. I didn't mean to state devastating precedent. It's devastating to Deutsche Bank's interest in the property because, like I said,
Just this property.
the property located at 8 Portland Street in Lynn, Massachusetts.
Right.
Right. So it's interest in the real
Although
estate.
you did just say that since you hold the note, you have a lot of different remedies.
But not under the mortgage.
I understand,
That's the
but you
problem.
said that
As
wasn't
Your Honor
important. You
pointed
can,
out-
apparently you can sue and attach things and,
But as Your Honor points out, even though they have those remedies, it's not remedies under the mortgage, right? They have to have that assignment of mortgage in their possession under Ibanez, or there has to be some other documentary evidence that would be admissible showing that the assignment was made before the bankruptcy, such as the pooling and servicing agreement, et cetera. But the document that is recorded in public land records is publicly available.
in light of this decision, have you gone to the bankruptcy court and asked the trustee to release the mortgage that our state court has said?
No, Your Honor, and that's the point that I was trying to reach with the devastating consequences, is that this loan was sold before the bankruptcy was commenced, so this loan was never an asset of the trust, of the bankruptcy trust.
I agree with that, but you have a holding below that the mortgage is.
Correct, but
And
if
does state property law tell the trustee what he or she has?
I think that it would be the bankruptcy records and what the records of what assets were actually transferred to the estate, because this is clearly wrong on the facts.
But there's a million intangible assets someone could have that might not be listed,
Certainly.
right? Oh, I forgot, I own the intellectual property in Burger World, you know, that one that's left in Texas, I still own that.
Correct, but here the pooling and servicing agreement shows that the loan was sold before the bankruptcy.
Okay, but I didn't ask you that. I asked if you'd gone to the bankruptcy court with this
We have not,
decision
Your
in
Honor.
hand
We have not.
to see if you can get them to at least release in a quitclaim way whatever they have of the mortgage.
We have not returned to the bankruptcy court at this
Okay.
point yet. And the reason is that, it's unlikely that the bankruptcy trustee could sign that assignment because he had no rights in this loan to begin with. He had no rights in the mortgage to begin with
Well,
because it was never
that's not what
transferred to the estate.
the final judgment in this case says.
Correct, but as I pointed out in the motion for reconsideration, Your Honor, that was a.
And Riley doesn't bind,
demonstrable error of
Riley
fact.
doesn't bind the bankruptcy court, an unpublished opinion of our court.
I'm sorry?
Riley doesn't bind the bankruptcy court, so.
Correct.
All right, thank you very much. It's an interesting case, at least to me. I don't, I don't know about everyone else in the world, but I find it very interesting. We will hear next from Attorney McCardle.
Good afternoon, Your Honors. Attorney Luke McCardle on behalf of the defendant appellee. Just, I guess, piggybacking on the discussion that's been going on, it's obviously an odd and kind of convoluted set of procedural and motion practice issues regarding reconsideration, 59E versus 60B. The judge, in fact, ruled on it pursuant to the substance of the motion, which was a motion for reconsideration of the order, not a relief from the judgment. So in order to find abuse of discretion, we're then going to have to invent an abuse of discretion on something that he didn't make a ruling on, which was on a motion for reconsideration of his order on the merits of the case rather than the relief from judgment under any particular subsection of 60B. And then that narrative changed with the appeal. Now there's a new argument that wasn't before the trial court on a 60B motion under 60B1. I mean, I guess the standards are relatively similar as far as, I guess, demonstrable error versus mistake of law or mistake of fact, but there was no mistake of fact or mistake of law on the then current record. The record that...
And that's because your position is the mortgage was an asset of the bankruptcy trustee.
That's
and
correct.
has never been properly assigned. And you won on that below, right? So you're now judicially stopped from saying anything else. So if your brother goes into the bankruptcy court and says, this mortgage was an asset of the estate, you can't go in and say, no, it's not, right?
Right, I mean, I wouldn't take that position, no.
Okay.
And as Your Honors recognized, there was the affirmative defenses. In these cases, you have a short period of time to answer, file discovery all in one, like 10 days, or it's a little more extended with the Tier 1 events now. But our affirmative defenses are lengthy, and they cover every possible avenue for an unlawful foreclosure once we get into the evidence. So to suggest that there wasn't theories within the affirmative defenses or the answer, and the discovery request to produce the agreements, the transfer agreements, the pooling and servicing agreements, the securitized, transfer into the depositor. We asked for these on all of these type of cases, and they just didn't produce them. So I have to be inclined to think that it doesn't exist or wasn't properly transferred or wasn't an asset of that trust at all. And then the record, when you look at a bankruptcy case, federal bankruptcy law suggests that any transfer within a bankruptcy proceeding or liquidation or event such as this one is considered a record assignment. So on that fact, which hasn't been disturbed by any other evidence, the judge made a ruling on the facts in front of him. And if the other facts that potentially refute that don't exist in his record, there can't be a demonstrable error, never mind an error at all. He applied the actual facts in front of him to the actual law, and both of his determinations were thoughtful. His first determination was very thoughtful, went through the res judicata issue regarding the prior state court judgment, went through the issue with the bankruptcy, distinguished Riley, which was very clear. His ability to distinguish it was very clear. The assignment is, pursuant to Ross, the assignment is voidable if you can show that the person who assigned it didn't have any right to assign it. It's very clear. That's the argument. It's void.
Voidable and void are different.
Right. Sorry, did I say voidable in the
You
first
said
place?
void. You said voidable first and void.
Oh, sorry. Yeah. Sorry. Void.
I mean, the two biggest arguments, res judicata and the assignment of the mortgage is invalid, were both made to the judge before summary judgment, and the judge addressed them both at summary judgment. And so the defense had, Deutsche Bank had notice and could have appealed and did not appeal, and therefore that is those issues at least are waived, right? And you cannot bring them back to life, reanimate them in a motion for reconsideration, right?
Well, I think that's the crux of it, is that they're trying to relitigate a second bite at the apple. There was the opportunity at the trial court stage. There's a hearing on the summary judgment motion, and typically they take it under advisement, 30, 60 days, make a ruling, but they actually said, okay, if you feel like you need to present more evidence, even though they had the opposition, they could have done a reply. Once there's a clear entire argument on, Ibanez's compliance and standing, if you're not going to, that clearly refuted their prima facie case, and it was their burden then to pick up and say, oh, no.
Maybe they should have hired Attorney Linehan
They
earlier.
should have hired him earlier, probably would have gone a different route. But in any case, I know Attorney Coletti too, and he knows his way around these issues, and I think it was more of client notice and telling him what to do.
Well, it doesn't matter why.
That doesn't matter. Yeah,
It doesn't matter
It
because it
doesn't.
didn't happen, right?
Yeah. No, it didn't happen. So, I mean.
And sorry, just to be clear, as an officer of the court, tell me the truth. Whoever you or your predecessor made this argument before summary judgment. We are challenging the validity of this summary process because the assignment of the mortgage was invalid, because it was assigned in 2015, long after they had gone into bankruptcy. So that assignment is invalid, so they don't have the mortgage, so they can't take possession, right? That was the defense, right?
Right.
Okay. And also, res judicata, you made the argument on res judicata, and that this was not res judicata because the issue wasn't joined, because Rosa didn't show up, defaulted. And whether or not that's a legally viable argument, that was the argument you made. The judge agreed with you, and again, Deutsche Bank was on notice for both of these things at the time of the summary judgment decision, right?
Yes, yeah, I mean, thank you. Yes, the judge was on notice of both of those arguments. They are well articulated. His memorandum and decision were well articulated. He cites the actually litigated was, one of his biggest points regarding this wasn't actually litigated, and there's an SJC case, I think Treglia, and then.
But even if Deutsche Bank is right and the judge is wrong, it doesn't matter because the remedy is to appeal, right? And they didn't appeal, right?
If you disagree with the judge, you appeal the decision, not try to circumvent this with, post-judgment and post-appeal time period, maneuvering to try to relitigate the merits of the case. And I don't even think the merits are before the court.
Are your clients parties to the mortgage or the note?
The tenants are not, no.
You call them tenants. Are they paying rent?
I
Is that in the
hope
record?
so.
To whom?
I'm not sure.
Who would they pay it to?
So there was an error in the record regarding the former owner mortgager being deceased. He's not.
Oh.
Yeah, I don't know where the trial court judge
And
came
is
up.
there?
Living there?
I'm not positive he's actually living at that property. It's a multifamily property. And that actually brings up another issue.
Is he collecting rent? I mean, it's not what this case is about, but.
I hope not, because he should be paying me if he is. But,
Wait, sorry. Sorry. Mr. Rosa is alive.
Yes.
And Mr. Rosa, okay, that's good for him.
Yeah.
Wait, though, now I'm confused because his interest in the property, this changes many things. So or I don't know if it does.
Nothing.
Okay, good.
I know you sat down, but does everybody agree he's alive? Is that undisputed?
I told him this morning, I was like, yeah, I don't know how that got into the
We
record.
based our representation that he was deceased based on the housing court's finding, based on there's something in the record that was not in the order. I found out this morning that Mr. Rosa.
Okay, all right.
But that does bring up another issue regarding the two occupants and the two separate units, because there were companion cases brought at two different times against one unit tenant and unit two tenants. This judgment was entered separately, even though it was the same judgment, separately on two dockets in the housing court. They only sought reconsideration of the one.
Oh, yeah.
So it's another hurdle that just, it would almost make this moot,
So
in my
you're
opinion.
saying the other case then becomes res judicata on this case because,
Precisely.
okay.
So that hasn't been disturbed. It's a final judgment on the exact same issues. So then
So that even if they won here, they couldn't ever kick those people out.
yeah,
They wouldn't get possession of the building. There'd be people living in it.
Yeah, it would create quite the convoluted posture of events over
Well,
at the
we've already
property.
got that.
Yeah, we've got that anyway. Some of these cases are quite interesting. And this is certainly one of them, but
Do you represent Mr. Rosa?
in the past, my office has represented Mr. Rosa, and
But you're here only for the current occupants
I'm
of one
here-
of the units.
correct, only one of the unit owners, yes.
Owners or?
Sorry, unit tenants, not owner, yeah, sorry, I'm
Okay.
losing it. But
But you don't know, there's no order for use and occupancy to be paid to Deutsche Bank?
No,
Okay.
no, they didn't seek one. I don't think it would be applicable to an appeal where we were the winning party.
Well, we can't do it. No, I'm just
Well,
wondering.
dealing with that situation in another case, it's pretty.
I'm just
pretty odd.
wondering I mean, no one's paid this mortgage for a long time.
That's correct. I agree with that. I mean, the equitable aspect of it is not really in play today, but
Yeah, I
there-
understand
there,
that.
there are some equities involved, and some steps that, certainly my brother will have to take to correct this.
Do you agree that they own the note?
I mean, that's another issue. I mean, it was argued extensively in the briefing and today regarding the note, but they could have also shown that they own the note. That was another aspect. If they did show they own the note and that they were due.
Was this a defense also, that the actual ownership of the note, I don't know what phrase I want to use here, hasn't been proven, or?
That was actually an argument. It wasn't a determining factor by the trial court judge, but it was an argument because they produced two distinctly different
Yeah, I remember.
copies of
Yeah,
the
yeah,
original
yeah.
note. I mean, I left it behind because, we moved.
That's not what this is
We moved forward
about,
on
yeah.
something else, but it was part of the summary judgment record, and it was an eaten argument regarding compliance with, having both the note and the mortgage, either one.
What year was the mortgage issued?
2006,
Six, I think.
Six,
I was going to
five,
guess, yeah.
Six.
yeah.
Right, but before everything.
Yeah. And I'll rest unless your honors have any other questions.
No, thank you very much.
All right,
Thank you
thank you.
both. I think it's interesting, but I hope others do. The final case we will hear, the case is submitted. The final case we will hear this morning is number 25480, Gladstone and others versus Dennazard. Now, am I right? There's some division of time on the part of the appellees? Is that right? How are you dividing your time? I had something that told me, but I don't see it here.
10 minutes for me, Attorney Giles Krill on behalf of plaintiff appellee Jerry Gilling.
You're representing just, here it is. So you're representing just Gilling, but you're having 10 minutes, and you're representing,
I represent all the parties,
including Gilling?
including Gilling, but Attorney Krill is addressing the majority of the brief because the same arguments apply to the other clients, with the exception of the issue that I will address in my 5 minutes.
Which is,
Whether or not there's been a relocation of one of the easements.
oh, I see, yeah, no, we know about the Tabor trustees, yeah, okay. All right, so with that, apparently, we will hear first from Attorney Krill. Oh, no, that's wrong. We will hear first from Attorney Libardoni, who's actually the appellant. All right.
May it please the court, David Libardoni for the appellant, Kathleen. Your Honors, this case is about 6 neighbors, all of whom have rights to use a beach, who have come together to sue the defendant, Kathleen Dennazard, claiming that they have more beach rights. The land court, we're here because the land court wrongfully concluded that 4 of these plaintiffs, the Gladstone, Gillings, Tabors, and Tabors trustees' properties, have deeded easement rights over Ms. Dennazard's property.
But the Tabor trustees
Yes,
have a different argument than the other 3.
that's correct.
And that argument is, since there was never merger, and on the face of it, one might think that they continued to have the 3, I don't remember, 19 rights. Wait, which is the one that was occupied?
So
Yeah.
I'm happy to start with
But I just want to make sure I understand it.
Yes.
But that there is a deed that says in front of, and
That's correct.
there's an argument that that is a relocation of what was in the original 319 deed.
Yes.
All right, let's do that last, I guess, and go to the three that are the same.
Sure. And before I do, Your Honor, just at the very outset, just want to make clear that even if you find in our favor on all four of these plaintiffs, the case still needs to be remanded to the land court because there was an alternative claim that Ms. Dennazard raised that was never heard about.
What is it?
That to the extent that any of the plaintiffs have deeded easement rights, that those plaintiffs are overburdening those rights, and that's.
But the judge ruled on overburdening.
I don't think there was overburdening. There was factual issues that needed to be developed.
I thought your point was there weren't factual issues because as a matter of law, there's a black letter rule, and the expansion of the 318 parcels with the these parcels with the 319 half meant they were all, as a matter of law, overburdening.
So there's a distinction that
and the judge, I think, kind of said, well, if there had been merger or something, they would be, but I'm not applying merger.
Yeah, the distinction, I think, is between overloading, which is the issue we want to focus on, and overburdening. But just to quickly wrap up this issue, overburdening gets to whether if you have an easement right, whether the intensity and use of that easement right is within the scope of the easement. And that's a factual inquiry, and this was hotly in dispute between the parties. There was no findings of fact related to that. What you have in this case was.
Does the judge not say that their right to use the beach, if they have it, includes the right to use the beach?
Based on the record title, but whether have they been using it in that manner was an issue of fact that was never developed below.
And you also, at least in your opening brief, indicated that you don't think that your counterclaim is that they can't use the right-of-way either.
So that is only for the Tabor trustees, Your Honor, and that's because that party, the easement to use the farm shore was relocated to just the front of the lot. The basis of
I thought in your counterclaim you said none of them could use the right-of-way, and that you're now saying, well, if all they have is rights to pass and repass, then that's how they have to go, so we're abandoning that. Am I right about that? I mean, I'll ask the other side as well.
We're not disputing that the Gladstone.
Did you dispute in your counterclaim that all three of the Gladstone, Gilling, and whatever
We did. Originally, we did, yes.
You did?
Yes.
And what's the basis for that? What was the basis for that?
Sorry, you now are not disputing that.
We are not disputing that.
And you're not asking for it to be sent back so that can be considered?
That's correct, we're not.
Okay.
I'd like to stick with the Gladstone, Gillings, and Tabor's properties.
Okay, and is it clear that the fee interest under the right-of-way is yours, your clients?
The southerly half is our clients, yes. And the northerly half is owned by the Seymours, the plaintiffs in this case. So issues of merger and overloading as we, is the heart of our brief and affects three of the plaintiffs' rights here. These three plaintiffs, their properties were formed from portions of the 318 parcel and portions of the 319 parcel. The portions of the 318 parcel that are part of these plaintiffs' properties, their rights in the farm shore were merged as a matter of law in 1909 when a common owner owned most of the 318 parcel and the south farm shore.
Right.
Okay, so you're referring to a map then on Record Appendix 4, page 223, and you're saying that Henry Dennis owned the whole green area that's marked as 209/382 parcel, but he didn't own the Seymour Tabor parcel, and he didn't own the 1905 Bachelor parcel. Is that right?
That's correct. That's correct.
And so because he owned the Dennazard parcel, and he owned parts of Gladstone, it's not entirely clear to me he owned part of Tabor's, but he owned Gladstone and Gilling and maybe some of Tabor's, that caused the merger.
That's right. And merger acts to extinguish an easement, as if it never was there to begin with. And in order to revive those easement rights, they would need to be created anew.
Yeah, but the exciting part of this is the 319 part of it, because what you're arguing is, I think, what the other side will say is the thing that you're really, the crazy part of your argument is that you're asking that merger extinguish the easements in the 319 portions of their properties, right? And do you have a case where overloading, not overburdening, overloading has ever been held to extinguish pre-existing easements?
So Your Honor, I just want to be clear. Our argument is that overloading allows a court to permanently enjoin a property's use of an easement because it's been, after acquired property has been added
Right.
to the
This is your reply brief note, whatever the end there. You're destroying distinction between. We're not saying we're not destroying their easements. We're merely permanently enjoining them from using them.
Yeah, and
one of
that's
those distinctions I just don't get.
Well, it's very clear from Taylor that the SJC has directed that the courts are allowed to, as one of their remedies in this situation for overloading, to permanently enjoin a property.
Okay, fair enough, but
yes.
Taylor, since you brought it up, Taylor is the one presidential case we have. That's not about, I think, please correct me if I get this wrong, it's not about extinguishing pre-existing easements. It's about connecting two hiking trails. But they don't, I think, the SJC in Taylor does not hold that the pre-existing easement before the overloading is now either destroyed, extinguished, or permanently enjoined, right?
That's right, Your Honor. What the extinguishment is really important here because you have to understand that 56 years elapsed between when the 318 portion of these three plaintiffs' properties, that the 318 easement had been extinguished. So now that when Dennazard's predecessor acquired the Dennazard property back in 1914, those easement rights were extinguished. The 319 parcel's easement rights were still affected the Dennazard property. Now we get to 1965 when the 319 parcel portions had the rights and the 318 portions did not.
And Hemingway joined them up.
Correct.
Right.
Correct. And what Hemingway did was they granted rights to use other portions of the beach to these parcels, lots 6 and 8 on the Hemingway plan.
Yeah, how does that actually work in practice? That sort of was, I'm sure in the record there's more explanation, but I get it from the map. 319 extends all the way to the beach, and lot 6 is, I guess, the beachfront piece of that. I don't know who owns lot 6, but are you saying, this seems important, and there's not very little explanation in the briefing, that Gladstone, Gilling, and Tabors today have the right to walk down what's essentially 319, walk east and right onto the beach?
They can access the beach on lots 6 and 8. Those rights are granted to them by the Hemingways, to their predecessors, and is in their deeds in the record. And that's where they can enjoy beach rights. They can also enjoy the North Farm Shore because that portion of the farm shore never merged.
So the only question I have for you, because I think I understand your merger and your overloading? I don't remember which it is.
Yes.
I thought, okay. I think I understand those arguments. Why should they have to walk down this right-of-way instead of across the beach? I don't understand that.
The right of, so that gets to the issue of their preserving their North Farm Shore.
Yes, of course. Yeah.
And these were, at the time of severance, when the North Farm Shore and the South Farm Shore were separated in 1909, the right-of-way existed at that time, and these were inland portions of the 318 parcel. And honestly, the quickest way, and what was reasonably necessary...
Well, before he bought it, Henry, whatever his name is, they could use the beaches for anything. They could walk across them to get to the North Farm Shore. They could plop their chairs down right there. Maybe they could build a bathing hut, or whatever it says in there, right on any part of the beach. Mm-hmm. So maybe there was a right-of-way, but so what?
Well, I think when when the right to use the portions of the farm shore were merged in 1909, that still left the 318 portions with the right to use the north farm shore. And how do you actually, now I can't use the portion of the farm shore that merged, how do I actually get to the north farm shore? I can use the right-of-way and take a left and go up to the north farm shore. I cannot go down the right-of-way and take a right onto Dennazard's beach. That doesn't give me
But
access
can I
to
go
the north
straight
farm shore.
down and take a left across Dennazard's beach, and then the rest of the south farm shore, and then get to the north, right? Because that's what the judge has allowed them to do.
Yeah, well, I think we cite a few times to, and it's obviously not binding on this court, but there was a Superior Court case in Bristol County that involved a lot 1 in the Hemingway plan that's in the same chain of title as the Gladstone, Gillings, and Tabors.
Sheehan v. Hemingway.
That's correct.
Yeah.
And where that court found that there was no right, even though they had rights to use lots 6 and 8 in the Hemingway plan, there was no right for that party to cross over the intervening private properties, including the Dennazard's property. But I want to get back to overloading because I think it's really important for this court to understand that the burden should not be on the servient owner to be subject to these rights when the after acquired property did not benefit from this easement. There were arguments made, the land court seemed to suggest that there was an exception to Taylor and an exception to merger by saying that if the easement was intended to benefit both properties, that somehow overloading doesn't apply.
I didn't see that defended in the opposing party's brief. I only saw them argue that Cheever doesn't apply to servient estates that are only partially merged.
Yeah, I think they're also trying to say that we're somehow arguing that an easement, that overloading extinguishes in an easement, and we're not.
Well, they're saying, I guess they're also saying that for certain reasons that we'll ask them about, that this after acquired property rule doesn't apply, and we should be looking at facts and circumstances to see whether these are overburdened rather than a bright line rule. I think they're saying that too.
Yeah, and Taylor expressly forbids that. And I would also urge the court to look at a recent appeals court decision, not binding. There was a Rule 23 decision, McGuire versus Planning Board of Hamilton. And Justice Rubin, if you recall, that was an overloading case where the similar facts, land benefited by an easement, land not benefited by an easement, came together, and there was residential subdivision with 3 separate lots, and the court in that case determined that overloading prevented the use of an access easement, even though the parties had moved the houses to the benefited portion of the parcel and even said, we'll put a fence between the benefited and unbenefited portion of the parcel. It's a bright line rule, and it's not the court's job to assess the burden on what the servient owner. It's the parties to decide. And in this case, Dennazard and her predecessors, who have owned this property since it was created 110 years ago, have never assented or consented to any others having easement rights.
In that Planning Board of Hamilton unpublished Rule 23, did the court extinguish or permanently enjoin the use of pre-existing easements?
The action in that case had to do with a subdivision approval from a planning board. So the court upheld the land court's decision to deny the approval of the subdivision plan because it relied on an access road that these plaintiffs could not use due to overloading. So you didn't get to whether, essentially they were permanently enjoined.
They didn't already have, I'll look at it, okay.
All right, so why doesn't it matter, though, that the after-acquired portions of Gladstone, Gilling, Tabor properties on the 318 parcel did have at one point similar easement rights to the 319 parcel? Why is that not significant for overloading, that it's not overloading?
Yeah, a couple of responses to that, Your Honor. First is the inquiring about the nature and history of the after-acquired properties is is not something that Taylor promotes. It's not about, that gets into the type of factual inquiry that Taylor prevents and the bright line rule prevents. Second, these easements were not the same. They were same use in a similar area, but they were two distinct easements with distinct parties benefited by the easement, the Dennis brothers and Lewis Richardson with respect to the 319 parcel. And finally, looking at whether it had originally been intended to have rights to the shore, you can't look there because the rights have been extinguished for 56 years. So it's as if the easement had never been created. This parcel, when you look at the overloading question in 1965, when after acquired property came in through the Hemingway plan, the 318 parcel never had those easement, the 318 portions never had those easement rights.
So jumping back to the implied easement regarding the Gladstone, Gilling, Tabors properties within the 318 parcel, you agree that their easement rights to the North Farm shore were never extinguished, right?
I agree with that, yes.
Okay. And it does seem that you now agree that everybody can use the 10-foot right-of-way except the Tabors.
Tabor trustees, right.
Tabor
Because they
trustees.
have, their easement is, I know I'm over time, but their easement was relocated in 1899.
Do you have a case that stands for the proposition that the owners of jointly owned property, one of whom owns the servient estate, can, in a deed that they issue, not on the behalf of the one servient estate owner, but both of them, that's a way to negotiate or reach an agreement to alter an easement?
Yeah, the deed that created the Tabors trustees parcel, which was the deed to Walter Knowles, that the parties to that deed were Henry Dennis, who owned the dominant estate, and Ephraim Dennis, who also had a partial interest, and Ephraim Dennis, who owned the servient estate.
Henry Dennis did not own the estate. It was owned by both of them. Right? The dominant estate was owned by both of them.
That's correct.
Okay, and that's who sold this, or wrote this deed, or whatever, granted the deed.
That's correct. And so Ephraim Dennis, who owned an interest with Henry jointly, also was the sole owner of the servient estate.
But it had not merged.
Correct.
Because, right? Okay,
Correct.
so now?
So what happens is, and they granted Walter Knowles rights to the beach in front of the lot. And I would find it,
and how does that extinguish, how does that replace the much better easement that he was already getting to use the whole thing as a beach?
Well, first I look at the deed itself and compare it to language.
Why would I think if the person who owned the servient estate was not this Henry and Ephraim, it was just Ephraim. Why would I have any idea that I was giving away all these rights if I didn't make a deal with Ephraim to give away the rights in exchange for going just in front of my property, which I could already do under the easement, I think. Go right in front of my property. Why wouldn't I, I mean, it doesn't look like the way you would extinguish rights or trade them or move them.
Yeah, well, I think that's why we argue in our briefs. You have to look at other instruments of record that both Henry and Ephraim were parties to. And the one you really need to focus on is the William Hill deed in 1909, where Henry and Ephraim...
Why would Knowles have been looking at that? Is that in the chain of the Knowles property?
That Knowles wouldn't be looking at that.
Okay, but he's the one who's getting, is losing easement rights in this alleged deal. Right? He's the one who's losing the whole rest of the beach for something he already, I think, has. Right? He has the right under the original easement to use the beach in front of his property.
Well,
So why would he, if he doesn't see the Hill deed, why would he think, oh, this is taking away an easement right I have? I don't understand that.
I think that he accepted a deed from Henry and Ephraim with the plain language that he had the right to use the beach in front of the lot. And if you those grantors' intent It can be also, you can look outside this deed, as if it's not clear from the deed, as Sheftel supports, you can look outside the deed. Now we're looking at other instruments. Henry and Ephraim were party to a deed, the Hill deed in 1909, where they went through the effort of reciting each party's rights that in the North Farm Shore. They omitted Walter Knowles's rights. They included Edward Knowles's rights, who owned land west of the North Farm Shore. Not to make this more confusing than it already is, but it's.
This is after Knowles already owned it.
It is after Knowles.
So sometime after he gets it,
Yeah.
the other parties indicate that they thought that they were extinguishing it. But he's the one who gets the bad deal here, right? We have to see, did he mean to relocate his whole easement? I mean, what they think subjectively doesn't seem that important to me.
Right. I think it's important for understanding their intent because they were parties, and I would think if Ephraim was wanted to preserve, that.
He didn't want to, let's say, but Knowles has to know that he's negotiating away his rights, right? He has to know, you mean relocating the easement? Why don't you write that in the deed? And any other easement rights to the rest of my property or you don't have. All you have from Ephraim.
Yeah, better drafting obviously.
Well, or actually making an agreement.
But I think Knowles accepted the deed with language beach in front of the law. If he wanted to make sure that he had rights that were different than that, he could have had no language, because all the rights and appurtenances would have carried forward, including the rights to the established in the 318 deed.
But
he
at some point,
accepted a deed with that language.
in your client's chain of title accepted a deed that says with no encumbrances when there are some. Right? It doesn't mean that they're gone. There are encumbrances.
Mm-hmm.
Is this argument waived?
No, Your Honor, because the substance of the argument was made that the beach is limited to the beach in front of the parcel, and that's in the transcript of the cross motions for summary
Right, so
judgment.
for this one piece, you're relying only on Record Appendix 4, page 399, right? Where you say very expressly limited the easement to the land lying directly in front of it.
Right, which both the court and the other party were on notice of, which is the requirement under Chelsea Housing Authority.
So the plaintiffs argue at the beginning of their brief that we could affirm on an alternative ground that it's undisputed that Henry Dennis only owned a portion of the Servian estate, namely just South Farm Shore but not North Farm Shore, at the time he acquired title to the remaining portions of 318, so merger does not apply.
Mm-hmm.
I'm not clear we've covered your answer to that.
Yeah, my answer to that, Your Honor, is Cheever was very clear that the land area does not need to be coextensive, that you can have partial merger of both the partial dominant estate and partial servient estate, even though the facts in Cheever concerned just the less than the whole of the dominant estate.
It has a sentence that mentions the dominant estate. It's an open question whether, it seems to me, whether the servient estate follows the same rules. I can understand why it would, but I don't think it's answered by Cheever.
I think Cheever, the principle announced in Cheever didn't distinguish between the land areas. It was applying that principle to the facts in that case, which concerned less than the whole dominant estate. It relied on a treatise, which made very clear that the...
No, I thought your argument about the treatise was stronger than just the argument that it held that.
Yeah. And, I'm way over.
You're way over, but we're asking you questions.
Yeah. So And there hasn't, the other side had to look at cases outside of Massachusetts to look at this question of whether it's 100% of the servient estate or not, because we just haven't had a case with less than the whole of the serving estate. But the principle in Cheever should still apply and extends to both sides. The cases that the other side relies upon, those were easements that require, access easement over multiple parcels, where you need each parcel to have the benefit of that easement. Here, you don't need the entire farm shore to have the benefit of using just a portion of it for boating, bathing, and fishing purposes.
Is it correct that your only theory to extinguish the rights derived from the 319 parcel is this overload doctrine?
On appeal, yes, Your Honor, yes. It's really the combination of overloading plus the extinguishment by merger issue.
So you say that if overloading plus,
Overloading, and it relies in part on the extinguishment by merger argument.
Of the 318.
Yes, yes.
You want to ask another question?
no, I think I'm good.
All right. Thank you very much. Thank you for all the extra time. It's very helpful. This is obviously a very complicated case. So thank you very much. And now we will hear from Attorney Krill.
May it please the court, Attorney Giles Krill for the plaintiff appellee, Jerry Gilling. On the merger issue, I'd actually like to pick up with the treatise that was just discussed a moment ago, the treatise cited in Cheever, the American Law of Property treatise. Number one, the appellant talks about how the treatise goes on to discuss that not only can the servient estate, not only can there be a partial merger as to the servient estate, but that partial merger can go on to extinguish the rest of the servient estate that's outside the merger. The authorities cited in that treatise for that proposition are cases from England in the 1500s. Now, certainly our common law system is grounded very heavily in the English common law system. This is not one of those cases where it is. There is no such case anywhere in the United States that adopts that aggressive position.
No, I understand, but he's not arguing for that position.
Oh,
He's
I
arguing.
know.
He's arguing that the portion of the servient estate that was owned by the property owner of these, of the 318, half of your client's parcels, that part's extinguished, even though the part he didn't own of the shore farm isn't extinguished.
I understand that, Your Honor. But I think what they were trying to do in their reply brief was say, well, look how reasonable.
Let me ask you a question about, well, first, so you were not defending exactly what the judge said, that there's some kind of merger exception where once upon a time a plot without an easement had an easement. You're not defending that. You're saying, right, the judge says, for reasons I can't understand, even though these seem to have merged 50-something years before the subdivision was created, I'm going to say that because once upon a time they had easement rights, I'm not going to apply merger when they're half of a parcel where the other half still has easement rights.
Okay, I read his decision slightly differently.
I may be reading it wrong.
Starting with the overload extension of it, he did say the Taylor case, it's on the overload issue, because the Taylor case.
I'm asking about the merger because he says I'm not applying merger.
I disagree. I think what he said was I'm going to only recognize a partial merger, but they, not as to at a minimum, they would still retain a right of access over the south farm shore to reach the north farm shore.
But the judge doesn't give them just a right to access, he gives them the full easement rights.
He declines to extinguish the easement rights over the parcel as it's now configured on the basis of overload, because even as to the 318 half of their lot, in his view,
let me ask this question a different way, because this is not really getting to what I'm trying to get at. You agree that it's half merged. You agree that the 318, the portions of this parcel in 318, that was merged, and that those halves don't have the easement rights they did when it was originally conveyed.
The common ownership occurred, but I am arguing that as an alternative basis for affirmance.
You're saying, but the basis for your non-merger is Cheever doesn't apply to servient estates. It's not anything else. If Cheever applies to parts of servient estates, then merger. Maybe no overloading, but yes, merger.
Yes, but I also think it was well within the judge's discretion to only do a partial extinguishment by merger, in the sense that he didn't claw away their rights of access over the
over it to get to the north.
Yeah. So it's a twofold argument. I'm saying on the one hand,
I assume you want your full easement rights, though, right? You don't want just to be able to access. Presumably, you want to be able to use the whole south farm shore. I don't really know what the distances are. Maybe I'm wrong about this. Presumably, you want to be able to plop your chair anywhere there, right?
Correct. And to that end, we are making a twofold argument, two alternative arguments. Number one, alternative basis for affirmance. Cheever does not apply to Servian
All right, let me
estates.
ask you about that.
Can we just hear his answer? You're making,
Oh, I see, I'm sorry.
you're making your alternative argument, that's how you started your brief, right?
Yes.
Okay, and your second argument?
We should affirm, the judge is correct that at minimum, the 318 parcel did not lose the right of access, because then you would, as I said.
Doesn't he concede that, basically? He's trying to argue that it's overloaded, but he does concede, or that it should be enjoined, but he does seem to concede they have the right-of-way access, and they can turn left. Are you trying to say there's more, they can turn right?
Oh, but I'm not talking about the 10-foot right-of-way. I'm talking about the portion of the Dennazard beach that was
But that
adjacent to the
concession,
318
that
parcel.
concession, they can go down the right-of-way and turn left, is a concession, not about the scope or where you can do it, but that you retain your right of access even if you have to cross over some of South Farm Shore. They say it's not the part in front of their house, but they do acknowledge that you can cross over part of South Farm Shore to get to North Farm Shore.
Okay, well, we're on to a different issue there where it concerns whether I think what we're talking about here is whether the right-of-way easement that the judge recognized that they've waived appellate rights on.
I'm not
whether
asking that. I'm just asking whether I believe they are conceding that you continue to have some right of access across some part of South Farm Shore to the North Farm Shore. I think they're conceding that. They say it doesn't include in front of their house, but they're not saying you can't get there if you have to cross South Farm Shore.
Well, no, they're saying that there is no right of access over the South Farm Shore.
Only because of the right of way.
Correct. That is their argument. And to
I
that
thought they were saying that you can be on the, I'm trying not to use north and south because it's already North Farm Shore and South Farm Shore, but when you go down the right of way, you can turn left, which is still South Farm Shore.
Yes.
And you can go over that to get to North Farm Shore, right?
As we sit here today, based on the judge's ruling, that is a legal right.
But your position is they can also cross over if they choose, cross over South Farm Shore the whole way. The judge said they could, didn't he?
The judge said they could, yes. And I want to really emphasize that, in my view, when you're looking at merger analysis, the court has to look at the Servian estate, and only the Servian estate. There's no authority that where a merger occurs, the court can look to other extraneous pieces of land, such as the right-of-way, and use that as a basis to comfort itself that we're not reaching an untenable result here by slicing up the Servian estate. There's no precedent for that proposition. Certainly, a century ago, no one, when we talk about the intent of the parties, no one had the foresight that they were going to waive on appeal their challenge to the 10-foot right-of-way.
So when the 318 parcel portions of Gladstone, Gilling, and Tabor properties were merged with 319, or added to 319, did that convert the 318 parcel into an after-acquired property for each of those families for purposes of overloading?
If you accept the defendant's argument that there was an extinguishment that occurred, that I say no, as the judge said, no one probably intended, given the original language of the conveyances. If you accept the defendant's argument that Cheever applies to Servian estates and the judge was wrong that there wasn't even an access right that survived, then yes, it would be an after-acquired property. But I say that those are both incorrect conclusions to reach.
Well, if there's a right of access, it didn't survive. It's by implication. Nothing survived. There was merger. But wait, we still have rights to the North Farm Shore. Yes, and so by implication, there's one parcel for which this is clearly necessary to decide, right? Isn't that right? I think there's one, Seymour, something, maybe I'm wrong. But the idea would be you don't have your easement rights anymore except to North Farm Shore. Oh no, how will you get there? You have a right of access to the rest of South Farm Shore for crossing and recrossing to get to it. But you can no longer plop down your chair. I thought that's what your alternative ask is, isn't it? by
yes,
implication, not by survival.
I personally look at it as, I mean, we've cited cases where the court can decline in other jurisdictions, compelling jurisdictions, New York, California, where the court can decline to even apply merger. If that's the case, I say it's within the judge's discretion to, in law school, we referred to property rights as a bundle of sticks. He could just take fewer sticks out of the bundle, so to speak. So but maybe that's just semantics. And incidentally, when it comes to easement by implication, I want to add that in the defendant's brief, they misapply easement by implication law. Traditional easement by implication law refers to when land is held in common ownership. There's a severance of title out of common ownership if there's some obvious use on the ground that carries forward by implication. It doesn't refer to easements arising by implication when servient estates are carved up. And in this case, the judge gave my client the easement over the 10-foot way, not by that version of easement by implication analysis, but rather the Murphy v. Olson secondary easement iteration of implied easement. And I know my time is out. There was one extra point I wanted to get to on the treatise cited by Cheever that I wanted to bring to this court's attention, if you're willing to indulge me.
Yeah, go ahead.
Number one, the key quote that is relied on by the defendants when they look at Cheever is, of course, the quote, "For unity of title to extinguish an easement, it's the ownership of the two estates that must be coextensive and not the land area comprising the dominant and servient estates." The first part of that quote about the ownership of the estates being coextensive, that's a well-grounded principle in Massachusetts law. Cheever cites Massachusetts law for that proposition. Second part of that sentence, only thing they cite is the treatise, okay? So the treatise, when you look behind the treatise, the only thing the treatise cites for that proposition is Restatement First of Property, Section 497. That section of the restatement doesn't stand for that proposition as I read it, and certainly not as to the.
Well, Cheever might be wrong, but we're stuck with Cheever. If this was a dominant estate case, we wouldn't even be talking about it, right?
My point is Cheever's not as well, that part of Cheever that relies on the treatise doesn't have this long, well-grounded history in Massachusetts law, and that's why I think if we're going to expand it to the servient estate and all the attendant problems that creates, I do think it's well within this court's discretion to take another look at it and consider the practical realities of carving up, slicing and dicing servient estates and how non-tenable that is for the reasons we tried to articulate in our brief.
I have a question. Tell me what's wrong with this analysis. Cheever should apply to servient estates as well as dominant estates for the following reason. Henry had, let's pretend he bought them in this order, although he probably didn't. Henry had some properties that had easement rights over a beach. Then he bought the beach. Now he can do anything he wants on the beach. He doesn't need easement rights. He owns every right in it. At the end of the day, if he decides to sell the property that used to have the easement over the beach, but he still owns the beach, and he wants to let the people plop down their chairs on the beach, he can write that into the deed. But maybe he doesn't want to do that. Maybe they'll sell for less, but he doesn't want to do that. He wants his beach to be, he's the only guy who can plop down on it. So now he gives them deeds, but it doesn't have this old easement in it. Now, maybe someone has a right to get to the North Shore because of the happenstance that he only had part of it, and so he can't extinguish crossing and recrossing. But plopping down chairs, he just doesn't want that. Why can't he do that if he owns it all? But they have a right to cross and recross to get to the other part.
Well, number one, your fact pattern is he owns the beach, he owns the lots next to it, he conveys out there's a merger. In your hypothetical, I guess there's a pre-existing easement over the beach.
From before, which it's this case, right? 318 had a pre-existing easement all the way over the beach, and then he bought 318 and the beach.
Well, again, in this case, the term, the servient estate is the farm shore. In your hypothetical, the beach is
I'm asking,
just the beach
yes,
next to his
I'm
land.
asking why we don't simply, that's, I think, the basis for the dominant estate chiever rule. You don't need this anymore, you own everything. But why isn't the reverse true if it happens to be that the servient estate is the part he buys part of? He owns both.
Okay, two answers to that question. Number one, where Henry's beach is not the original servient estate of the deed, it's only a part of the original servient estate. Again, I think that leads us into these absurd hypotheticals where you could have owners in a subdivision with a private road. If they own the land next door, all of a sudden there's a little pocket of an extinguishment, and the next thing you know, the private road starts to look like a checkerboard. And I just think of easement rights, and I think that's not tenable. And number two, in the real world, people don't. In the real world, I think people often don't anticipate these consequences in advance where property enters common ownership. And if they,
Well, I've clearly had cases like that. Mergers may be a really stupid idea, but it happens all the time, right?
Well, like I said, these conveyances occurred many decades before the Cheever decision came down.
But
so.
are you saying, in looking at this color map on record, Appendix 4, 223, you're saying that Henry, for the whole South Farm Shore, that he only acquired the Dennazard piece, and did he also own the part that was to the right of the Tabors and the right of the Shermans?
The Tabors and Sherman, did he own the portion of the farm shore to the right of the Tabors and the Shermans? I have to confess, I want to say yes, he continued to own that farm shore. I'm not 100% on that. It's a pretty complex record. I do want to say that yes, he did continue, but going off memory, I do want to say the answer is yes to that.
So then the merger wouldn't affect the rights to the right of the Tabors and the right of Sherman? Is that then what you'd be saying?
Well, they're not my clients, so the successors in interest.
No, but your clients are Gladstone, Billing, and Tabors, and so then you'd be saying they can still use to the right of the Sherman and the right of Lot 6 and Lot 8, which are not marked on here, but look like it's the two Valois properties.
I wish I knew the answer, whether those deeds to those parties ran to the sea or whether the deed called for the stopping point being the beach, and I just don't know that answer as I sit here now. But either way, I mean, really, the only issue in the case is Dennazard. The only controversy before the court is that Dennazard doesn't want people in front of her section of the beach, which Henry Dennis certainly did own.
All right, thank you. Thank you for the extra time. We will hear from Attorney Cataudella.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, my name is Mary Cataudella. I am going to join in Attorney Krill's argument on the merger issue and rest on the brief on that. I'm going to address the issue I believe Justice Wood raised it very briefly, is whether or not the issue of the relocation of the Tabor trustees' easement was raised below and can be addressed by this court. I think Justice Henry grabbed onto the fact that in their reply brief, the defendants only raised the fact that where the easement was located in front of the property, that was the only place that it was raised in oral argument. It wasn't briefed as expressed in both the appellant's brief and in their reply brief. They are now asking this court to go through an analysis of a relocation argument that was not raised below. So I would ask that the court not consider that as an issue at this point.
So the word relocation isn't used here in this that I see?
Exactly, Your Honor. Relocation was not even used in the small section that was cited by the appellants in their brief, and it was not briefed below and addressed by the court specifically. And as the case law suggests, both in my brief and the appellant's brief and reply brief, that involves specific inquiry about intent, possibly abandonment issues, and those simply weren't addressed by the court. If this court were to think that this was raised properly and should be addressed by this court, I don't believe, for the reasons cited forth in my brief, that there's been a relocation. I am looking at the actual deed to Noel's, which is located at Record Appendix 3, page 233, and that deed specifically says on page 2 that the conveyances are made with all the privileges and appurtenance thereto belonging to the grantor. And they concede that the Tabor trustees and their predecessors had the access rights. So there's nothing being taken away, and our position is that the fact that they state that they have rights to the beach in front of the house, in front of the property, is exactly what they had before, and there's no relocation.
What page, I'm sorry, what page are you on?
Record 3. You're talking about the reference to the deed, Your Honor?
Yeah, the reference to...
I have Record Appendix 3, page 233.
We have that as Exhibit 48.
We have that saying Exhibit 48.
Oh, 234, I'm sorry. Record Appendix...
So this hand...
RA 3,
Oh, I see.
234, I'm sorry.
Handwritten deed?
It's the handwritten deed. And if you look on, I guess it would be page 2 of that deed, 1, 2, 3, 4, 5 lines down, it begins with to have
And
said to hold the
To have
granted
and
premises
to
with all the
hold the
privileges and
premises.
appurtenances thereto belonging.
Wow.
So they already concede that this parcel had the rights. They're conveying it with those rights, and then they're stating something in my view that's pretty obvious. You can also sit in front of this property. There's no relocation here. It's just a restatement. So that would be the first. So the first argument.
Well, it's not a restatement of the whole, of all the rights.
No, it's not a restatement of all
Because
the
they
rights.
have rights, they had rights, that property had rights to the whole farm shore.
Exactly. So they pass it on. And even if it didn't say that in there, it's in the chain of title, so it would be part of their rights, which they acknowledge that they have.
Can I ask you a question? Well, no, you.
Well, so I understood before we started argument, it seems like this has now changed, but I understood that they were arguing we should remand just as to Seymour for overburdening and nuisance arguments, but he started the argument now saying it would be for all of the parties on overburdening.
Well, Your Honor, I don't think that this needs to be remanded on the overburdening issue. If you look at the court's judgment, the court specifically states that it is addressing the counterclaims 1 or 2, which deal with the overburdening issue. And let me just
You know what page that is?
Yeah, I'd like to see that too.
Just one moment. Here. Sorry, it's on the decision, the motion for summary judgment. I'm just trying to locate
So
it
an
in the
addendum.
papers. I
Start on-
apologize. Oh, I'm sorry.
Well, it seems to start on Record Appendix 4, page 297, but
Right, so if you look at page 95 of the decision on the motion for summary judgment, where the court says ordered and adjudged. The court specifically states, 1, 2, 3, 4, 6 slides down, it says that on count 1 of the defendant's counterclaim seeking a declaratory judgment of trespass, and count 2 of the defendant's counterclaim seeking a declaratory judgment with respect to limitations on the claimed easement as follows. And the court goes out to say everything that the parties can do on this property. It doesn't say what they can't do, but I think that that would be a limitless number of things. So this judgment does address the overburdening by telling everybody that's involved exactly what they can do on this property. And it lists it specifically further on down. For boating, bathing, fishing, all customary beach uses incidental thereto, including without
Where are you
limitation.
reading from?
This
'Cause
is
I'm-
on page 95 of the addendum to the appellant's
Oh,
brief.
I apologize, Your Honors.
Yeah, the document is entitled Judgment. Can I ask, something confused me. There was a reference to a private tort of nuisance, and that a land court judge doesn't have jurisdiction to hear a private, and I apologize, I didn't look at the complaint, I guess, or the counterclaim. I should have asked them this, but is this claim, count two, what is it in the nature of? Is it a private tort of nuisance, or is it a land court overburdening claim that the land court can hear?
Your Honors, I don't have the actual wording
That's all right, I'll look it up.
in
It's
fr-
okay.
in front of me.
It's okay.
But, I mean, the land court has jurisdiction. I know that the land court has jurisdiction for trespass claims as ancillary jurisdiction
Okay.
if it involves title to property. And that trespass is a tort, and it can award damages
Okay.
in that context. But they were not looking for damages in this case.
I have one other question, I think.
And I apologize.
Judge talks about passing and repassing over both the right-of-way and the beach in front.
Yes.
They say, no, just the right-of-way. How's the judge supposed to figure out where the pass and repass area is? Once they say, oh, yes, there's a necessary, by implication, you have to be able to get to the North Farm shore. So regardless of anything else, you have to be able to pass and repass to get there. How is the judge supposed to figure out exactly where that pass and repass is, right? I mean, the judge could say a 10-foot wide strip next to the high water line, or could say a 10-foot wide, or could say the whole beach, or is there any rule about that? Is that a matter of discretion, or?
I don't believe so. In this case, the judge said that they could pass and repass and didn't give a specific area.
No, I'm saying, I understand that, but let's say we were to conclude that that's all these, some of these people have. Maybe not the trustees, but maybe the three, whatever, Gladstone, Gilling, and Tabor. Where is the judge supposed to put the pass and repass? I mean, for example, could they put it on the front lawn? Could they, right, could the judge say, like, or is it a question of that's something that's left of the original easement because it's necessary? I just don't know, and maybe this isn't briefed or litigated here, I don't.
Your Honor, I suppose a judge could put restrictions on that and say you can only pass and repass between the high water mark and the low water mark that way, but that's not what the judge said.
Well, no, everyone has rights below the, right, you have to be above.
Right. Your Honor, that was left undecided. I'm not quite sure that that's what they were looking for in their declaration, to have a specific area. The rights that were granted in the past were just simply the rights to repass.
And below they said, there's no right to repass, not over the right-of-way, not over the beach. They were busy saying
Oh,
it
they,
merged,
yes.
yes, they were busy saying it merged and now it's overloaded, and so you have no right. But they conceded that you had a right to North Farm Shore.
Yes.
Did they mention how they thought you should get there?
I believe that what they were saying was we should go down the right-of-way and take a left.
You think they said that below? Because they were also busy saying you have no rights to the right-of-way. I mean, we can look at the briefs below.
I'm not sure,
We
Your
have
Honor. As
it
I
all.
stand here today,
Okay.
I'm not sure.
Very quickly, can I go back to your original answer on count two, nuisance claim? You bring us to this language in the A 95, for they have the rights to boating, blah, 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 all customary beach uses, including thereto, without limitation. Is that phrase, without limitation, in my mind, they're saying you need to remand because we need to address the facts of this nuisance claim, and I think they say there was no agreed upon facts about the nuisance claim. I still don't really know what the nuisance claim is, what the elements of a nuisance claim here are, but it sounds to me in my head like they're saying they could have, they're having like thousands of people running up and down the right-of-way, and I'm wondering if I'm right about any of that, but also if without limitation means, yeah, the judge already dealt with this, and the judge said they can have as many trips back and forth to do sunbathing as they want. They can go back and forth all day to do sunbathing.
Well,
they've dealt with that.
I think, Your Honor, what the court has done here, it has given these parties permission to do these specific things. If
Is there a
something
quantity
comes-
issue? I'm talking about.
Well, and that's what I was, it doesn't say that you can have bonfires. It doesn't say that you can sleep on the beach. If any of these parties, I think there's enough here that if any of these parties feel, if the Dennazard feels that any of the parties are in contempt of this order, then they would have to go before the judge and they would have to determine by affidavit or otherwise in a contempt proceeding or a violation of the order, is whether or not what they have done is in violation of what the court specifically said. So I don't think that a court can reasonably ask the trial court to put everything there that can't be done. They've said what you can do, and that's guidance for the parties going forward.
Okay, thank you.
Thank you.
Thank you very much. Thank you all. We appreciate the extra time, and I think it seems like we need it. So, thank you very much. Very interesting case also, and it is submitted. This brings us to the end of our sitting for today. I would like to thank the court officer and court staff for their excellent assistance as always, and we stand in recess.